One matter, fresh hearing, my lord.
Any matter will come on Monday. And what is the urgency to take it up out of the list?
My lord, we have filed section 14, section 14 petition that has not been considered by
We'll see
the.
it on Monday. It will come.
Please, my lord.
Give all the memos to the court officer. I will not take up any matter on the other 3 days. All can wait till that day. Yes.
Yesterday, my colleague moved a memo on DRT matter because.
You have given the date. I will.
The date has been given 17, but any moment I'll dispose the similar because of banker. Any moment I'll.
I will not interfere in that kind of disposition also, because you have a remedy of going before the TRT. So when there is, when your remedy or alternative remedy, when this court is.
We are ready to pay Milan.
No, you do it before the DRT also. DRT will also come to your rescue. So I will take up the matters on Monday and Tuesday. No matters out of turn will be taken up any other day. Yes.
My lord, the humble submission, my lord. WP matter GMFC.
Give to the court officer. Yes.
No, my lord, it was posted today, my lord, but it is not listed, my lord.
That also you can ask her why it has not come.
For the child to be.
Huh? It will come on Thursday and Friday.
Please, my lord.
Yes.
Page-wise adjournment.
No adjournments required. Call the list.
Yes, sir. For being spoken to, list number 1, serial number 1, Gudev Prasad KT, for appellant, N. Krishna Swamy.
This is with regard to the applying new act
Yes.
for pay and recovery. Lordship, may kindly, the earlier judgments were not based on the proviso to section class 4 of the act. It is also, the
147.4.
sharp point is 147.4 only. The word, the policy was issued during the 2021.
Let's see. What was the provision earlier? What was the provision now? I think we'll take it up at 2:30 because the list is heavy, like, so that I can enable to spend time in the afternoon. Afternoon. Yes, next, call the list.
Afternoon or some other day. Yeah, I will take minimum 1 hour or more.
List is matter next, then list is matter in the month of December. Yes.
Serial number 2, for dismissal matter, Bhanu Prakash.
Respondent claimant, my lord. Last occasion, my learned friend not appeared.
Yes.
That's why dismissal. My lord, the claimant appeal in 2.1, my lord, for enhancement. The accident.
14/10/2025, as there was no representation on behalf of the appellant, the matter was directed to be listed for dismissal today. Today also there is no representation. Accordingly, dismissed for non-prosecution. Yes, what about your appeal?
My lord, the accident occurred on 1/11/2017, my lord.
It's a case of death or injury.
Case of injury, my lord. The doctor assessed 45% permanent disability of left upper limb and lower limb, my lord. And 15% to the whole body. The tribunal taken only 8%, my lord.
Come to the table.
My lord, there is no table in the
Where
judgment,
is
my
the
lord. In synopsis, my lord. My lord, the pain and suffering, my lord, 80,000 was awarded, my lord.
Adequately awarded.
There are 5 fractures, my lord. The compensation awarded under the head of pain and suffering is on lower side. And the compensation, my lord,
How many injuries?
5 injuries, my lord.
40 plus 4, 80,000.
80,000.
Yes,
The compensation towards, my lord, laid up period, my lord, not awarded, my lord.
medical expenses. Why it is not awarded?
The tribunal has not assigned any reason, my lord.
Let's see. Come to the order, page number.
Page number, my lord. Regarding disability, my lord, the page number 19, my lord. Running page, running para 13, my lord. Bottom 3 line, my lord. Third line. The doctor assessed of 45% disability, but the tribunal taken only 8%, my lord. And the income taken, my lord, only 7,000. As per chart, my lord, 11,000 has to be taken, my lord.
How many days he was in hospital?
10 days, my lord.
Which year is the accident?
2017, 11,000.
What is the multiplier?
Multiplier 13, my lord. 15 year. 50 year as on the date of accident.
Yes, please come. Agreed with the award passed in embassy number 401 of 2018, dated 9th March 2021. With the fifth edition district and session judge Skiptur, the claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by the claimant. The tribunal has awarded the compensation as per the table given below. The table is at page 2, synopsis. The land counsel appearing for the claimants of this when this accident had taken place in the year 2017, the court had taken the income at 7,000, ought to have taken the income at 11,000. Further, it is submitted that when he has sustained 5 previous injuries, and the head of pain and suffering, the amount that is awarded by the tribunal is not a reasonable amount. And under the incidental expenses also, court has failed to grant a reasonable compensation. Further, when the evidence of the doctor is that he has sustained 40% disability to the
40.
limb, and 15% to the whole body, court without any basis had taken 8% or 7%.
8% as well.
Court had taken 8%, and under the head of loss of amenities, the amount that is awarded is not adequate, and under the head of under the head of laid up loss of income during the laid up period, no amount is awarded. It is submitted that on all counts, the compensation needs to be enhanced. There is no representation on behalf of the respondent. Even the appeal that is filed by the respondent is dismissed for non-prosecution. As there was no representation on the last occasion, even on today also. Next part, having heard the counsel for the appellant insurance appellant claimant, peruse the material on record. When it comes to the pain and suffering, medical court had reasonably awarded an amount of rupees 80,000 and no interference is called for. Medical expenses 27,056. As he was in hospital for 10 days, and at the head of incidental expenses 10,000. Coming to the loss of earning during the later period, as this accident had taken place in the year 2017, this court is taking the income at 11,000 into 33,000. Then the loss of future earning, the doctor has reported that he has sustained 45% disability to the limb and 15 to the whole body. The court without any basis had taken 8%, so 8%, and this court is inclined to take the disability as per the evidence of the doctor at 15%. 11,000 into 12 into 13 into 15 by 100 is 2,57,400 for a disability of 15%. Under the head of loss of amenities, this court is granting 30,000. And in the light of the law, like laid down in Mekala versus so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,47,456. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 2,47,360 to 4,47,456. Yes, next.
There is a 589 days delay, my lord.
Was it condoned?
Without.
In the docket order, I number 1 of 24 to condone the delay of 589 days in filing, condoned on the condition that they are not entitled for interest for the said period. Now, in the operative portion of the order, this clause should come.
Please.
Bill number 3, P. Mahesha for appellant, Samarth Prakash for R1.
Yes,
Respondent, Your Honor. Accident is of the year 2018, my lords.
let's see the table.
My lords, table is at ink page number 47, my lords. For pain and suffering, I've been only awarded 40,000, my
Which
lords.
matter you are putting 100. Where is page number 41?
Bill number 3.
47, my lords. MFA number 1331 of 2024. Lords,
Your,
internal page number 18 of the judgment, my lords.
yes, because the judgment ends at 29 pages, only of 29 pages.
Lords, ink page number 47, ink page. I have put the page numbers, my lords. Internal page number 18, my lords.
Entire page itself is 36.
Lords, there might be a problem with I'm sorry, my lords.
Internal page,
18, my lords, of the judgment. Award. Yes.
yes.
Lords, pain and suffering have been only granted 40,000,
What
my
are the
lords.
injuries?
Lords, head injury, my lords, there are 4 injuries, my lords.
Hmm.
If your lordships may
What
kind.
are the grievous injuries?
Lords, there are grievous injuries, my lords. Disability is at 55%, my lords.
Come to the injuries.
Please, my lords. Internal page 10, my lords. Paragraph 17, the petitioner has deposed so and so. He deposed that petitioner sustained subdural hematoma in the left fronto-temporo-parietal convexity with hemorrhagic contusions in the left frontal lobe and fracture of the occipital
So it's
bone.
an injury to the head.
Please, my lords.
So another 20,000. Yes.
Lords,
Medical expenses.
medical expenses, my lords, have been granted only 81,000, my lords. I had given medical bills of 1,21,000, my lords.
What to do now?
1,80,000, my lords.
If you are on the medical expenses, I will not go into it. I
Very
can't
well, my lords.
calculate
I'll leave it to your lordships, my lords.
it. Yes.
With respect to income, my lords, if your lordships would kindly come to,
To just wait, as whatever the court has, accordingly to the answer will go.
Please,
Pain
my
and
lord.
suffering, medical expense. How many days was in hospital?
11 days, my lords.
Huh?
11 days.
How much is granted?
My lords, 200 rupees per day, my lords.
That's what will be granted. Incidental expenses 7,200.
Please, my lords. Conveyance charges only 2,000, my lords. Last
The hospital for 11
11 days plus.
So whatever it is, I am granting 11,000. Whatever is granted by the court, we will not look into it. 11,000 for everything. Then loss of income during laid up period.
My lords, only 10,000 has been granted, my lords.
Here is this accident.
2018, my lords. I'm a 50-year-old lady, my lords.
2018,
my lords. Notional income should have been taken as 12,500, my lords. I'm a milk vendor and an agriculturist, my lords. Only 3,000 notional income has been taken, my lords.
Future medical expenses.
That's future medical expenses is at 30,000, my lords.
Reasonably granted. No enhancement is called for. Then what is the disability according to the doctor?
55%, my lords. That has been taken by the tribunal.
55%?
Total disability, madam. Total body disability.
Let's see where is that court has considered.
That's internal page 12, my lords. Last paragraph. In this regard, the avocation of the petitioner as to whether the injury of the loss of capacity, her body is almost disabled by 55% due to fracture.
No.
Now, my lords, there's one more, my lords. Internal page 10, my lords. Proof of disability, para 17, my lords. Is unable to do the routine work and arrived at permanent disability to toe test and walking on a single line at 20%, and the disability to whole body is about 55%. That has been taken, my lords.
How much is granted under that head?
Lords, under the head of proof of disability, my lords. Now, future loss of income due to disability is only granted 2,57,400, my lords.
What is this? When the court takes 55% disability, then for future prospects have to be considered. How the court has arrived at this 2,57,000? No, taking the income, which year is this?
2018, my lords.
So 12,500. What is the age?
50 years.
50
my
years.
lords.
50 years.
Multiplier is 13, my
1
lords.
minute. Future prospects 50 years is 10% or
10%, my lords.
it comes to 1250. It is 13,750 into 12. What multiplier is?
13, my lords.
13 into 50? 5.
Please, my lords. 50 years. 55 is the disability. 55%.
It comes to 11,79,750. Amenities will grant 80,000.
Lots of amenities is only granted 5,000 rupees, my lords. And conveyance charges 2,000 only, my lords.
And entire incidental expenses I granted 11,000.
Only 7,200 was granted. And very well.
It's coming to 15,01,889 against
4,32,839.
4,32,839.
Please come.
Lordship, submission, there's a delay of 633 days. A conditional.
Not be entitled for
conditional.
interest. Please come. Agreed with award pass and embassy number.
1589 of 2008.
18 of 2018, date 11 November 2021. by so and so, where the claimant is before this court seeking enhancement of the compensation. The claim petition is filed claiming compensation of an amount of rupees 12,50,000 for the injuries sustained with the claimant in the accident. The tribunal has awarded the compensation as per the table given below at paragraph 19 extract. When counsel appearing for the claimant submits that when the claimant had sustained a head injury and the head of pain and suffering court has granted only 40,000. Further, under the incidental expenses, then the loss of income during the later period, court has not granted a reasonable compensation. Coming to the loss of future income, when the court has taken 55% disability, the court had not granted future prospects and granted an amount of rupees 2,57,400. And the said calculation made by the court is without any basis. It is submitted that under the head of loss of amenities, 5,000 is granted in the whole body disability is 55%. It is submitted that on all the counts, the compensation that is awarded by the court is not just and reasonable. Next paragraph. When counsel appearing for the respondent submits to the court considering all the aspects had granted a reasonable compensation and no enhancement is called. Next, having heard so and so, there is the material on record. Considering the head injury that is sustained by the claimant and the head of pain and suffering, this court is granting 60,000. Medical expenses 81,139. Incidental expenses for 11 days hospitalization. This court is granting 11,000. Coming to the loss of income during the later period, this accident has taken place in the year 2018. 12,500 into 450,000. Future medical expenses. The trial court had granted 30,000 and no interference is called for. Coming to the loss of future income, when the court had taken 55% as disability to the whole body, considering the age of 50, the court ought to have granted 10% future prospects. But the calculation arrived at by the court is without any basis. Hence, taking the income at 12,500, 12,950 future prospects, and the income is 13,750 into 12 into 13 into 55 by 100 is 11,79,750. Considering the 55% disability, loss of amenities 80,000. In the light of the law laid down in Meghalaya so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 15,01,889. The appeal of the claimant is partly allowed, enhancing the compensation from 4,32,839 to 15,01,889. Next, the docket order. I number 1 of 24 is filed to condone the delay of 633 days in filing. The delay is condoned for the reasons stated in the accompanying affidavit on the condition that they will not be entitled for interest for the set period. They should come in the operative portion also. Yes.
Cell number 4.
Obliged.
Absent.
Obliged.
Appellant. Adjudication.
Came little later, informed to the other side, take pass over.
Why were you not present earlier last time also?
Last time as well.
No, why did you not tell Mr. Vijay Kumar that he requested? Why did you accept?
I already phone call I get pass over. It happens.
But I'm submitting. I was submitting that, my lord. Last occasion not appeared. That's it, my lord.
This is not fair. When he said, asked you to take a passover, why did you accept it? Number one, because you will take passover, he has not come. So you as if you kept quiet, as if like he has not appeared. Court went ahead, passed an order, wasted time on that. Now he comes and says that he asked you. That order passed in so and so 2 and 2.1. Delete that order. List these matters 2 and 2.1 in the month of April. Yes, next. Yes.
4, I appear for the respondent, my lord. Respondent number 3. 4.
Cell number 4 now called.
Where is the?
Girish assent.
Do the proceeding sheet. When the matter came up on 15/10/2025, As there was no representation on behalf of the petitioner, the matter was directed to be listed today and the capture for dismissal. Today also there is no representation.
But he seems he is not well.
Who?
Girish SN.
Anyway, if Girish is not well, he should tell somebody. Dismissed. Next.
Cell number 5.
Apply for appellate, my lord.
Patel.
Filed for enhancement, my lord. Lower court has wrongly awarded. The lesser unreached.
Why you don't, why you are not coming when the matters are listed?
I am an NMC worker.
Your name is not Sunil Kumar.
No, my lord. NMC worker.
Yes, Liberty General Insurance, who appears? Pradeep is directed to take notice on behalf of the second respondent. First respondent is necessary party. Give a memo. Memo is filed seeking dispensation of notice to R1 dispensed with at the risk of appellant. Admit post of final hearing, call for the DCR.
Cell number 6.
Give the memo right now.
Pawan Chandra Shetty.
Yes.
My lord, office has raised the objection under section 173 sub clause 2 of the act. According to the, my lord, sub clause 2 of the act, saying, my lord, when appeal is prepared, my lord, there must be a claim more than 1 lakh rupee. So only on that ground, my lord, office has raised the objection. My lord, my humble submission before this honorable court, the judgment of the Meena Devi, the Honorable Apex Court has said, my lord, when the trial court is permitted to grant more compensation when, my lord, the claim is less.
No, please tell the facts first. What was the claim that was made before
Please,
the tribunal?
Please, my lord, 1,42,500, my lord. Accordingly, the learned trial court has, my lord, granted 50,000 rupees award globally, globally. So remaining is, my lord, 92,500, my lord.
So how do you get over that provision?
Yes, my lord. The appeal is, my lord, the office has raised the objection, my lord. The recent view which has been taken by the Honorable Apex Court, wherein it is held that, my lord, for the.
Where is the judgment?
Yes. Please. If claim is made, claim petition will not bar from the proceedings. If less claim is made, then, my lord, the spirit and language of the Meena Devi case is, my lord,
Let us read the particular paragraph.
paragraph number 14, my lord. Last but two para. Last page. At this stage, it is necessary to clarify that as per the decision of the 3-judge bench of this court in so and so, it was observed that under the MU Act, there is no restriction.
This is how this will apply to you.
Yes, my lord. I want
How
to.
this will apply
Yes,
to
my lord. I
you?
want to convince your lordship. I have been permitted to assist, my lord. My lord, the Honorable Affairs Court has said, my lord, if claim is less, court is, my lord, pass more award. When it is permitted so, my lord, the claim is, my lord, always it is for the consideration. Whether it is, my lord, the figure is, my lord, ultimately it is not a big issue. The jurisdiction point, my lord, will not suffer or lie from that. The claim amount is, my lord, it is restricted. Sometime we are restricting, sometime we are, my lord, it is kept open. The Honorable Affairs Court has said, my lord, by following the earlier judgment, Nagappa judgment.
For this, no proposition is there. Whatever is the compensation you sought, the court can always grant. That is a statutory one.
Yes,
How do
my
you
lord.
get over that?
That
It
get
is
over
on the
that, my
straight on the point. Now, for example, this judgment doesn't say about the provision. It says about on a general lines.
Yes, general lines.
That can't be interpreted in such a way that any law cannot be contrary to the statute.
My lord,
Any interpretation.
that is the Affairs Court judgment, my lord. By following the.
I will give that act.
Please.
Yes.
By following the, my lord, the full court judgment, which is in, my lord, Nagappa versus.
Yes.
Yes, ma'am. Then, my lord, one more judgment by the Honorable Affairs Court.
Yes.
The jurisdiction point has raised before the Honorable Affairs Court, wherein, my lord, the wrong jurisdiction has been selected by the claimant instead of, my lord, original jurisdiction. However, the Honorable Affairs Court, my lord, the observation of the Honorable Affairs Court that at paragraph number
Yes.
it is held that, my lord, at paragraph number, it is start from 2, my lord. The adopting the, my lord, no, not this, my lord, sorry, Oka judgment, my lord, sorry. This is something different. Oka judgment. This one, sorry. ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು. So Oka judgment, my lord, wherein, my lord, the Honorable Affairs Court at paragraph number 7, where it held that, my lord, hypertechnical is, my lord, not permissible when consideration of the claim. This is very hyper technical with respect to the, my lord, claim amount. So that, my lord, my humble submission before this honorable court, the best assistance is that, my lord, claim may be sometime, my lord, it is depends on the, my lord.
I understood, I
Yes, my
understood
lord.
that line of argument.
Yeah,
Please come.
So that, my lord, it may be kept open, my lord, for a moment. Notice may be ordered. If it is permissible, my lord, we can settle in the local.
I'm not convinced with this. The office has raised an objection with regard to the maintainability of the.
One humble submission, if permitted, I may permit it to amend the claim petition.
As it is now, where is the question of amending the claim
It is
petition
permissible.
now?
Under order 6 rule 17, I can permit, my lord. Claim petition at any time, even, my lord, in the RFA also, my lord, we are permitted for the, my lord, amend the, my lord, cause of action or prayer for the convenience of the litigant. So, my lord, it is, my lord, in the absence of, my lord, a specific claim, only regarding the figure should not get the, my lord, trouble for the consideration of.
Yeah, whatever you want to do on this office objection, I will give my, I'll pass order. Whatever it you want to do, you do it. The office has raised the objection with regard to the maintainability of the appeal. It is, the appeal is filed, the claim petition is filed seeking compensation of 1,22,500 and the court has awarded 50,000 as compensation. Now for the remaining amount, the present appeal is filed. The office has raised the objection that in view of the provision to section 173 of the Motor Vehicles Act, appeal may not be maintainable before this court since the value of the appeal is below 1 lakh. The learned counsel appearing for the petitioner had relied on the judgment of the apex court in Meena Devi's case. Meena Devi versus Nanuchand Mato,
Yes.
arising out of special leave petitions number 5345 of 2019. He relied on paragraph number 14, extract paragraph number 14. He has also relied on another judgment of the Honorable Supreme Court in case of Nirmala Devi versus Oriental Insurance Company Limited and others reported in 2025, ACZ 1490. He has relied on paragraph number 7. Relying on these two judgments and counsel for the petitioner submits that in Meena Devi's case, Honorable Apex Court has observed that more than the claim, that is more than the amount that is claimed by the claimant in the facts and circumstances, the court can always grant the compensation. Further, in the next judgment that is cited, that is in case of Nirmala Devi referred supra, the apex court has held that there cannot be hyper-technical approach in claim petitions, which is under the MV Act, which is a beneficial legislation. Next paragraph. The office has raised objection, view of section 173 of the MV Act.
Subclause 2.
173 subclause 2 of the MV Act reads as extracted. Entire and 173 extract. Subclause 2 of section 173 says, no appeal shall lie against any award of a claim tribunal if the amount in dispute in the appeal is less than 1 lakh rupees. either of the judgments that are relied on by the learned counsel has not referred to the statutory provisions and all these, whatever the observations of the court are general observations and which will not entitle the petitioner to prefer an appeal in view of section 173(2) of the Act, one proviso 2 of the Act. Hence, the office objections are sustained. Yes.
Serial number 7 for orders matter, Gopal Krishna N. For appellant, yes. For R2.
Second.
Huh? It is submitted that the needful is done.
Yes, please.
This is matter of service of notice. Next,
TCR may be called for, my lord.
it will be done.
Yes.
First of all, that it has to, they have to appear.
Yes, much
Yes.
obliged, my lord.
8,
Number 8, Vishwanatha K.
Kindly refer the matter to local
it is submitted. I number 1 of 24 is filed to condone the delay of 700 days in filing. Condone, same order like in the party submits the matter may be referred to the Lok Adalat.
Much
They
obliged.
refer to the Lok Adalat.
Serial number 9, Pradeep B. Uday Prasad KT.
Yes.
Pay the deficit, my lordship, one is necessary liability and the question, my lord. And claimants also filed an appeal.
R4,
R4, sir.
Take steps, my lord, 25 rupees deficit is there, my lord.
that's what the needful shall be done within a week default order. List along with so and so. Yes, 10.
Serial number 10, TDL.
In the first matter, take notice to FS Dabali, my lord.
Which
Is-
FS Zabali is directed,
Yes.
take notice. With that, it is complete.
Yes, madam.
Yes, I number 1 of 25 is 24. Is filed to condone the delay of 714. Yes. Next, admit final hearing TCR. What about the next one?
Any date may be fixed, my lord.
Yes, final hearing TCR. No dates now. Yes, 11.
Serial number 11, Raghu R.
Jagdish filed an wakalat, my lord. Wakalat is there, my lord.
Mr.
It may be
Mr. Jagdish has filed a wakalat on behalf of respondent number 2.
Two, my lord.
I number 1 of 24 to condone the delay of 87 days condone.
It may be
admit final
disposed,
hearing
my lord.
TCR.
Case
Disposed,
of
only
death, my
income, my
lord.
lord.
Only income, my lord.
Case of death, my lord.
Passover, 11 Passover. Yes, 12.
Serial number 12,
MO is filed seeking dispensation of notice to R1. Dispense with
It's only on quantum, your lordship.
memo for, in 2 also, memo is filed seeking dispensation of notice to R1. Dismissed with admit final hearing TCR.
serial number 13,
Memo for dispensation, dispense with admit final hearing. Then United India Insurance Company, who appears?
United India, R2.
Ms. Geeta Raj is directed to take notice on behalf of the insurance company. Admit final hearing TCR. 14.
14,
This was a memo filed for dispensation.
serial number 15,
For appellant, my lord.
Girish
Office
Chandra.
objection shall be complied with within a week. Default order. S16.
Serial number 16, Nayak,
Yes,
Devi Nayak.
My lord, respond number 2, owner of the vehicle, my lord. Claim petition is rejected, my lord.
yes, a week's time for taking steps.
Notice unclaimed.
Huh?
Postal Sarah unclaimed, my
Where do
lord.
you get that?
It is in the,
Postal Shara insufficient address.
the insufficient, sir,
Please.
not unfit.
Well, the needful shall be done within a week. Default order. Yes,
Serial number 17,
list after service of notice.
serial number 18,
My lord, I am for appellant. My lord, since appellant number 1 died, my lord, I made a note in the cause title and I produced the death certificate also, and that may be accepted.
The appellant number 1 is no more, and a memo is filed stating that the LRs are already on record and death certificate is filed and the same is accepted. Yes.
My lord, in connected matter, R1 is already served, my lord, so it may be held sufficient because only on interest point, my lord, I filed the appeal.
Admit final hearing this year. Next 19. Yes, Mr. Shastri.
My lord,
Note below cause title with regard to non-arraying of appellant number 1. He died
Yes,
after the
yes.
case, after or before?
after death, after the disposal of
But
the
then you
trial
have
court.
to array him, then the note below.
Yes, I made a note to that effect and I produced a death
First of all, you have
certificate.
to lay him as a party. Number one died.
Number
Then
one
the
died,
note-
yes.
Yes,
Yes, I
the
made-
petitioner, 18, the petitioner, the counsel for the appellant shall array the deceased respondent. And then then he can mention the note below. Yes.
Serial number 19,
So I have to file another appeal,
Yes.
19,
fresh appeal.
Memo for the dispensation of notice to R1 dispensed with.
Delay of
Then
13
IA 1 of 24, 13 days unknown, admit final hearing. PCR 20.
20,
Appear for appellant in this
Ravisha,
matter. Respondent number one, insurance company states that
It's insurance company.
New India Assurance,
New India Insurance,
Who appears for New India?
Assurance,
Mr. A.M. Venkatesh is directed to take notice on behalf of the insurance company. IA number 1 of 24 to condone the delay of 66 days. Condone, admit final hearing TCR. In this,
21,
For appellant, my lord.
wherever the person is directed to appear, in that the appellant shall serve the copy of the appeal memo on the counsel.
much obliged.
serial number 21, Girish SN,
For appellant, my lord, 1 week time may begin.
A week's time default order.
serial number 22,
Whenever I say a week's time default order, a week's time is granted for complying with the office objections. Or else the plea shall stand dismissed without the reference to the court. Yes,
serial
22.
number 22,
In this case, I'm appealing for appellant. In this case, we have challenged the liability. And the owner placed ex parte before tribunal. There is no deal. I am filing memo for dispensation.
Liability falls on against you owner.
If he is doing it, he's doing it his own risk. What to do? The memo is for seeking dispensation of notice to R2.
R1.
R1, as he was placed ex parte before the trial court, the memo is taken on record. And the notice to R1 is dispensed with at the risk of action. IA number 1 of 24, delay of 954 days, condoned on condition, admit final hearing TCR.
A case of death, my lord. Case of death.
Pass over, 22 pass over, will hear.
Much obliged.
Yes,
serial number
23.
23, Guitar,
Respondent, my lord.
On negligence can be disposed of instead of sending the records, my lords.
This is matter on 20th.
Much obliged.
Much obliged,
Grateful,
my lord.
24.
serial number 24,
Memo
But
is
I am
filed-
for HDFC is the R1, my lord.
Dispensation of
HDFC is the R1. Any advocate may kindly be directed to take notice.
HDFC Ergo,
Yes, Pradeep, you appear.
HDFC Ergo, B
So and so
Pradeep,
is directed to, Mr. Pradeep is directed to take notice on behalf of the insurance company. IA 1 of 25, 68 days condone the delay above 100 costs on condition, below 100 condone. Yes,
serial number 25,
memo to R1 dispensed with. What is this non-mailing of
But,
certified copy of the amended impugned
The
order?
date of the accident is wrongly mentioned in the judgment. In one side. Throughout the judgment, it's correctly mentioned in only one.
Admit final hearing TCR.
Lord,
26.
R2 is concerned, my lord, directed to take notice.
Who is R2?
HDFC.
You appear, Mr. Mulkan? Huh?
I'm not appealing.
Yes, Pradeep is directed to take notice on behalf of the insurance company. I number 1 of 25 to condone the delay of 1,222, condone on condition.
serial number 26,
It is no delay in this?
No delay.
no,
Yes, 26.
admit,
26.
admit,
Admit final hearing TCR.
26, Vivekananda TP,
R2 is?
United India Insurance, United India Insurance, K.
Ms. K. Nagaraj is directed to take notice on behalf of the insurance company. In this, the delay is 1,222.
Yes.
Condone on condition. Huh? Oh, they are not here. So 26 for dismissal tomorrow.
serial number 27,
It is submitted, the needful is done. List after service of notice 28.
28, KSRTC R1,
For the appellant, 28.1.
Hmm.
KSRTC served, my lord, will serve the copies to
Please.
KSRTC,
KSRTC, my lord.
FS,
Mr. Zawali is directed to take notice on behalf of the first respondent. Admit final delay of 114 days. Condone. There is no condition for this. Condone. Admit final hearing. Oh, this is Srinivas MI. You are representing
My
him.
Srinivas claimants was represented on behalf of claimant.
You are representing on behalf of him.
No, my lord, MI Srinivas representing on behalf of the claimant in connected.
For next matter.
May I
So
connect?
114 days on condition in 28. 28.1 for 84 days condoned. In this also, R2, Mr. Dabali is directed to take notice. R1, Mr. Srinivas MB.
Yes, ma'am.
He's already undertaken, my lord, he has to file wakalat.
No, Srinivas MB is directed to take notice on behalf of respondent number 1. Respondent number 2, Mr. Dabali, admit final hearing TCR. 28.2.
That is delay of
IA 1 of 25 to condone the delay of 84 days condone, admit final hearing TCR.
cell number 29,
Memo for dispensation of R2, then delay of 618 days condoned on condition,
Excellent, my lord.
admit final hearing.
cell number 30,
First obliged.
30,
What is the R1 may be dispensed?
Memo is filed seeking dispensation of notice to R1 dispense with. R2 is
New
New
India
India
Assurance.
Assurance, my lord. R2 and 3.
Mr. A. N. Krishnaswamy is directed to take notice on behalf of the insurance company. I number 1 of 25 to condone the delay of 523 days condoned on condition. Yes, 31.
31,
New India.
Connected matter, my lord.
Huh?
Krishna Kishore is appeared. Post along
Mr.
with minutes.
Krishna Kishore is directed to take.
1235 of 25 minutes. Connected matter. One more.
Post along with,
1235 of 25. Please.
post along with so and so.
Double to it. Refer to local adalat minutes.
It is submitted, the matter may refer to the local adalat.
Please.
Yes, referred.
cell number 32, KB Nayak,
Notice to second respondent returned with the postal shara and claimed amounts to deemed service of notice. I number 1 of 25 to condone the delay of 60 days condone, admit final hearing TCR.
number 33, Uday Prasad, Gala Kumar for R2. Not answered.
I represent second district.
Petition shall do the process shall be filed within a week. Pay shall be paid within a week or else the appeal shall stand dismissed as far as R1 is concerned.
34, Harish Babu
Memo
KN.
is filed for dispensation of notice to R1.
Let my name may
Dispense
kindly be deleted. I don't represent HDFC.
with
Lingraj may be directed to
Huh?
appear. Lingraj.
Mr. H.S. Lingaraj is directed to take notice on behalf of the insurance company. Delete the name of Mr. Ravi S. Samprati. You serve the papers on him.
Please.
Admit final hearing TCR.
Cell number 35,
Memo for dispensation of notice to R1 dispensed with delay of 1018 days condoned on condition. Admit.
36,
Whenever delay is condoned, admit final hearing TCR. This is directed to call for the decision.
Appear for the appellant in this.
36,
Appear for the appellant in this case. ma'am. United India Insurance Company.
United India General Insurance.
Mr. Ravish Mani is directed to take notice on behalf of the insurance company.
95,
95 days.
95 days delay condoned.
Please.
37,
37, KB Nayak,
a week's time for furnishing the PF
38,
as far as R2 is concerned. If the same is not default order,
38,
My lord, I am for appellant. R2 is the Cholamandalam, my lord. That is why.
Cholamandala who appear,
Cholamandalam,
to appear, Mr. So-and-so
Muralidhar Rachana.
is directed to take notice on behalf of the insurance company. Memo is filed seeking dispensation of notice to R1 dispensed with. I have 1 of 25, 10 days delay condoned. Admit final hearing TCR.
Cell number 39,
What about 39?
Krishna,
A week's time may be granted to file wakalat.
You can list this matter after service of notice to R1.
Cell
Yes.
number 40, Malati TN, private persons, R1.
This is matter. No, R2, as per the postal shara, notice to R2 returned as refused amounts to deemed service of notice. The needful shall be done within a week for service of notice to R1, or else the stay grant, or else the appeal shall stand dismissed against. Yes, next 41.
Number 41,
First along with MFA number 2841 of 2025.
List along with 2841. Then what about the other things?
My lord, 1 week accommodation may be
A
granted.
week's time, default order.
cell number 42,
List this matter after service of notice to R2 and R3.
43. United India.
Huh?
United India. Respondent number 2 is United India.
Mr. L. Srikantra is directed to take notice on behalf of the insurance company. I number 1 of 25 to condone the delay of 150 days, condoned on condition, admit final hearing this year.
44. Range Gowda.
Memo for R2 dispensed with.
R1
I number 1 of 25, 836 days, condoned on condition, admit final hearing this year.
R1 United India.
I'm for.
Sangeeta Aris.
Already she has filed wakalat.
45. Jagdish Shetty.
Empty similar, only one respondent is.
Mr. Dabali is directed to take notice on behalf of the respondent. I number 1 of 25 to condone the delay of 337 days, condoned, admit final hearing this year.
46. A.N. Krishnaswamy.
I'm appealing for the appellant, my lordship. My lordship, requisites are furnished course of the day, and I need to verify the 50% of deposit before.
What you should do, having
In week-
obtained the stay, order was
That's
passed on 6/8/2025.
I'll furnish the requisites to a course of the day, my lordship.
The petitioner shall file, the appellant shall file a memo with regard to deposit of 50% of the awarded amount within 1 week, and the process shall also be furnished within a week, or else the appeal shall stand dismissed.
Obliged, my lordship.
47.
Memo for dispensation to R1 dispensed with I 1 of 25, 683 days condoned. Admit final hearing this
Ready,
year.
Millard.
Ready? Pass over. After this list, I'll take. Yes. 47 pass over.
48.
This order,
Yes,
no final hearing. As far as the order is concerned of delay and all. Yes.
48
40.
Millards. Cholamandalam.
48.
48 Cholamandal, who
Pradeep.
appears for Cholamandal, you appear. Pradeep is directed to take notice on behalf of the insurance company.
There is
I
delay of-
number 1 of 25. Delay of 177 days, condoned on condition. Admit final hearing
Any
TCR.
date, Millards, simple
49.
matter, Millards, any date. Only the,
2025, all simple matters only.
The only
We will-
income is-
We will see 49.
49.
For second response.
Bring for the appellant.
Dispensation.
As per the postal shara, notice to the second respondent,
Unclaimed.
return unclaimed amounts to deemed service of notice. I number 1 of 25 to condone the delay of 74 days, condone.
Delete the
Admit
name
final
of
hearing.
C.R. Ravishankara.
Yes,
Sir, delete the name of C.R. Ravishankara.
I have filed the wakalat.
Keep the name.
we will delete the name of Mr. C.R. Ravishankar. Next 50.
Serial number 50.
New India Insurance Company, Millards, respondent number 2.
New India Assurance Company. Mr. B.C. Sitaram Rao is directed to take notice on behalf of the insurance company. Admit final hearing TCR 51.
51. Anup Sitaram Rao.
List after service of notice.
My lord, in 51, my lord, there's an office objection regarding the order copy from the MVC matter, my lord. Please, in the page 8, my lord, it stated that the accident dated 2024, my lord. Undisputedly, the case before MVC is on 2023, my lord. There's a small correction in the year stated in the judgment, my lord. And
Where is that?
in judgment page number 2, my lord, page 8 of our petition.
On
In the first
26/4,
line,
2024. Then that mentions as 26/4.
2024, my lord. But everywhere else it is stated 2023. There's a small mistake in the judgment copy. Hence, there is an office
The
objection.
office objection with regard to the date. Non-file certificate, office objection is rejected. Yes,
Much.
After service.
yes.
Then number
Notice,
52.
list the matter after service of notice.
52. Gurdev Prasad Ketty.
Our each time default order.
Serial number 53. For applying my gods.
List this matter after service of notice to R1.
Serial number
Much obliged.
54. 54. B. Pradeep.
For the appellant,
Lakshmi
avoid
Kant.
service of notice to.
List after service of notice.
Serial number
53 also list after service of notice.
56.
Yes,
S. Dabali.
55, my lord,
55.
1 minute.
respondent number 2 is the Tata AG General Insurance Company.
56 is Mr. in
55.
55. Which is the respondent?
Tata
Respondent
AG.
number 2, my lord, Tata AG.
Pradeep is directed to take notice on behalf of the insurance company. Then the service is completed.
Please,
55, Mr. Pradeep, Admit file nearing TCR. Next 56.
It's FS Dabali.
I pray for a week's time and just I will get information.
Why 38 order? Why are we waiting till now? A week's time for filing the memo, or else the appeal shall stand dismissed.
Cell number 57, Geeta R.
For appellant, my lords. Insurance company appeal on liability. My stay application was not considered because a caveat was filed pursuant to me filing the appeal. We have served a copy through WhatsApp, my lords.
Yes. On what ground you are before?
It's a liability appeal. As per the charge sheet, the driver was charged under section 181 for having driven the vehicle without driving license, my lords.
How much is the amount granted?
The amount awarded is.
Case of death or injury?
It's a case of injury, my lords. 5,09,300, my lords.
There is no representation on behalf of the respondent caveator. The land counsel appearing for the insurance company submits that insurance company is on the ground of liability. Accident before amendment or after amendment?
Accident occurred on before amendment, my lords.
It is submitted that the pay and recovery is not ordered.
Not even that is.
It is submitted that the driver is that the driver of the offending vehicle was not having a valid driving license. The tribunal has fixed a liability on the insurance company, and the insurance company is not liable to pay the compensation. Considering the submission of the council, they shall be stay on the condition that they shall deposit an amount of rupees 4 lakhs and within 4 weeks, and then the respondent is at liberty to withdraw.
First step to 225.
Steps to R2 I would take, my lords, within a week.
The step shall be taken in respect of notice to R2 R5 a week's time, or else appeal shall stand dismissed against the respondents.
Much appreciated.
58. Bhagirathi L.
For second respondent.
Dispensation memo to respondent number 1 and 3.
Memo is filed seeking dispensation of notice to 1 and 3 dispensed with. Yes. Admit final hearing TCR.
Cell number 59.
Appearing for the appellants, my lord. Respondent number 3 has preferred an appeal, my lord. MFA 6516 of 2025, my lord.
Along with so and so.
Cell number 60, bus police. 60,
Yes, 60.
Nagendra Kumar K. A. Venkatesh for R2.
I'm for R2.
Furnishing of PF for R1.
Yes. The appeal shall be done within a week, or else, yes, the appeal shall stand against respondent number 1. 61.
61, Spurti Hegde.
I pray for a week time, my lords.
A week's time default order.
Cell number
Yes.
62.
62, your lordship, I filed a memo for R1, R2 served, R3 insurance company, that universal shampoo.
Memo
general
is filed seeking dispensation of notice to R1 dispensed with. R3 is?
R3, universal.
Yes, Mr. S.V. Ekde Mulkan is directed to take notice. Admit final hearing TCR.
Cell number 63. C. Shankar Reddy.
Representing out of station.
Award amount. A week's time, memo shall be filed with regard to depositing of the amount and the PF shall be furnished within a week for R2, or else on both these grounds, the appeal shall stand dismissed.
64, D. Pradeep.
Take steps to R1 and.
Post as per the postal share notice to R1 returned as unclaimed amounts to deemed service of notice. R3, R2 and R3.
No such person R3.
Yes, sir.
I will take.
For R2 and R3, the petition shall take steps.
Served, my lord. Minor, represented by.
Oh, so only R3. The petition, the appellant shall take steps for issuance of notice to R3 or default order. Then for, what about non-filing of deposit?
Deposit, I will file the acknowledgement.
I think insurance company should do it in every case.
Sir,
It is
for the
happening.
appellant.
Problem is that, my lord, I will send the check to the trial court of the internal, my lord, they have not immediately.
Because Pradeep, yours is an institution. You are not individual.
Please, my lord.
So there
If
should
the,
be
my lord,
some.
the company is directed as.
No, there should be a mechanism in line. What we do
That's what
when
we
in 2-3 cases, if we vacate the interim order, so that the respondents will execute the order, then your insurance company will understand what is the procedure. Till such time, they are not understanding. I'm telling you from now onwards, if the
That's what,
copy
my
is
lord, I
not
am
filed,
requesting the Sanhok court to deposit before this court, then, my lord, they will send us, my lord, we immediately, within 2 weeks, my lord, we will deposit.
then
If
from
the problem is that, my lord,
but you can deposit. The court is not mentioning which where it is.
my lordship is rightly
Hmm.
held that, my lord, wherever you want, you deposit.
Earlier court, not some court.
But please file
Specifically
it,
mentioned
please,
MSc.
please file it. This is
Definitely, madam.
compulsory. I'm very much particular about this. Yes.
Cell number
In
65,
this
Raju
also a
S.
week's time for publishing the PF and also this. Yes, like 65.
For respondent,
Bring for the appellant.
Memo for dispensation.
Memo is for seeking dispensation notice to R1. Dispense with 1 of 25, 47 days. Condone, admit final hearing TCR.
66. Srinivasan MY.
This is matter of service of notice to R1.
67.
Bring for the appellant.
66.
67. PF for R1.
A week's time, default order.
My lord, 67, my lord, a small correction in the respondent name, my lord. It is stated BS Sitaram Rao, kindly BC Sitaram Rao.
In the cost title, the respondent name shall be reflected as PC Sitaramaro. Yes, 68.
Cell number
List after
68.
service of notice.
Bring for the appellant.
name may kindly be given.
Huh?
Is 68.
Delete the name of Mr. Ravi S. Samprati in 68.
Dispensation
69.
memo per R1.
59. NR Rangegowda.
A week's
Bail
time,
recovery
a
order.
week's time default, huh?
7.
Bail recovery order, my lord, will take steps to the
A
owner.
week's time default order.
70. NR Rangegowda.
70, my lord, notice to respondent number 1 may kindly be dispensed with.
I have
A memo
received,
is filed seeking dispensation of notice to R1 dispense with.
I have received the papers. Today I have forwarded to the company.
Admit
my lord.
final hearing TCR.
Number 71.
That's 1 week time may be granted for 71, my lordship. For taking steps, I have already taken steps. The office is
Next
some.
matter.
Cell number
A
72.
week's time default order 72.
72.
Memo is filed for dispensation to R2 dispense with.
my lord, ready, my lord. Ready, my lord.
I'm not ready.
Otherwise, it may kindly be referred to local.
Yes, refer to the Lok Adalat.
Cell number
73.
73. AM Venkatesh.
Lord, 1 week
Each time default order 74.
Cell number 74. SV Prakash. B Pradeep for R3.
List after service of notice to R1.
Cell number 75.
Respond number 2 is
And the office objections, number 2, the office objection shall be complied with. 75.
75. Pramod B.
I appeal for the appellants, my lords. Respond number 2 is IFCO Tokyo, my lords.
If court okay, who appear, Mr. S.V. Mulkan is directed to take notice. I number 1 of 25 to condone the delay of 62 days, condone, admit final hearing
Cell number
TCR.
76. 76. R2 and National New India Assurance.
New India Assurance Company. Mr. K. Nagarajaya is directed to take notice on behalf of the insurance company. I number 1 of 25 to condone the delay of 50 days, condone. 77.
77. R2 is Cholamandalam. R1 to 4. Respondent.
Any is not here.
Yes.
A week's time.
Cell number
No, in
70.
the earlier matter also, in 76 also, no advocate, a week's time in both the matters, default order. Yes, 78.
78, my lord, the respondent number 2 is the Cholamandalam general.
Cholamandala, oh, Pradeep appears.
Yes,
Mr. Pradeep is directed to take notice on behalf of the insurance company.
Delay.
I 1 of 25 to condone the delay of 64 days, condone on condition. No condition, condone. Admit final hearing TCR 79.
Cell number 79. Yes.
Memo for
Yes.
dispensation of notice to R1 dispense with. Admit final hearing.
80.
80 is R1 dispensation dispensed. I number 1 of 25, 70 days delay, condone, admit, final hearing. TCR.
81.
List after service of notice to respondent.
Respondent BMTs.
Next,
Cell number 82.
a week's time default.
Let
order.
Bharti AXA General Insurance Company.
Who appears for Bharti AXA?
Bharti.
Pradeep is directed to take
Please.
notice on behalf of the respondent insurance company.
Kindly refer to
Only
the-
one.
Only one. Yes.
I number 1 of 25 to condone the delay of 548 days, condone on condition.
Kindly refers to Lok Adalat.
To the Lok Adalat.
83.
List after service of notice to R2. Admit, after service of 84.
84.
R2
I
is
am for the appellant, my lord. 1 week time to pay PF to R3.
1 minute,
One
1
minute.
minute. United India.
83. United India.
United.
R2.
Mr. PB Raju is directed to take notice
Please, ma'am.
on behalf of the insurance company
Delay.
and delay of 388 days condoned on condition. admit file hearing. Yes.
84.
My lord, I am for the appellant. 1 week's time may be granted to pay PF to R3.
85.
Serial number 85.
1 week to comply the order, my lord. We'll furnish the copy in 85.
Non-filing,
for the-
move for dispensation notice to R1.
Next week we'll file it, my lord. There's
It
some
can be disposed of.
clarification needed.
For filing, list this matter up to 2 weeks. Case
Number
86.
86. Hearing on
86,
IR.
I am ready, my lord. Matter could be disposed of only on quantum, my lord. Right,
Pass
but
over.
taking-
One submission, Milan, instead of passing it over any other.
IA number 1 of 25 to condone the delay of 6 days, condone, admit file hearing DCR. 87.
Serial number 87.
My lord, I am for appellant. There is a delay of 226. Records is necessary, my lord.
226
Liability is
days.
in-
If he's asking, if you're asking for TCR, that means there is no point in your
No, no, negligence aspect is there. That is why no
condone
such.
the delay of 226 days, condone on condition, admit file hearing TCR.
88. Serial number 88. Ready, please.
52 days delay in filing.
152 days, condone, admit file hearing TCR.
Serial number 89.
35 days, condone. What is this?
No objection, 35 days.
No, even if you have objection also will condone.
Please.
35 days, condone, admit file hearing
Serial
TCR.
number 90.
Please,
Suresh.
Suresh.
273 days, condone, admit file hearing TCR.
Number
In any of
91.
these matters, Pradeep, if there is a case of death, you tell, we can take it up.
Serial number
91.
91. Death.
I pay for the appellant.
Withdrawal of amount, so and so, list this matter after 4 weeks. Yes,
Quantum
92.
only.
Huh?
91 not only quantum.
No, it says withdrawal of amount, so
They
and
have
so.
filed, I have deposited 50%.
It's a case of death. Pass over 91. Next,
Serial number 92.
Appellate
P.
counsel.
Suresh.
146 days, condone, admit file hearing TCR. 93.
Serial number 93. 532 days.
In this case, my lord.
532 days
Yes, my lord, kindly.
on condition. What is this?
It's injury case, my lord.
532 days
Quantum.
on condition, admit file hearing.
Serial number 94.
Much obliged.
So in the
Mr.
past,
Ajit.
I am for the appellant in the
Yes,
connected
appellant in
matter.
this case, my
if you see that there is TCR, then don't write. What happens is, come in. You don't have to get confused. In all this, the standard pattern is what? Don't have to follow and get panicked. So, wherever there is delay below 100, unknown without condition, above 100, unknown with condition. It is an appeal of the KSRTC or the insurance companies. It can be unknown without condition. Once it is admitted, that is admit finally, it is it. So this is standard pattern. Yes.
Serial number 94. Hello.
I am for the
94.
appellant in the connected matter.
I number 1 of 24, 54 days delay condone. In 94.1, memo of dispensation to R2, dispensed with, admit file hearing, TCR.
95.
Much
Raghua.
obliged, my lord.
17 days delay condone, admit file hearing. This New India Assurance Company. Mr. A. Ravi Shankar is directed to take notice on behalf of the insurance company. Delay of 70 days condone, admit file hearing, TCR. 96.
96. Vivekananda TP.
It's a New India Assurance Company in this also. Mr. Ashokan Patil is directed to take notice on behalf of the insurance company. 69 days delay, condone, admit file hearing, TCR.
57. Sushmita Ji. Notice as to
Appellant in this case, my lord. I pay for appellant in this case, my lord.
That's what notice to all are necessary or any dispensation.
No, my lord. All are necessary, my lord.
What is this appeal about?
Case of injury, my lord.
No, notice will be necessary in case of liability. Where is the whose liability is that? Fixed on insurance company or the? So you are not even looking at it.
No, my lord.
We are saying-
R1 in trial court, he has been appeared, my lord. Owner of the vehicle has appeared.
He has appeared.
Yes,
Liability is on whom?
This is only for enhancement, my lord. I'll file memo for dispensation in the course of the day, my lord.
This
Sorry,
is
ma'am.
matter. Notice to the respondent.
Much obliged.
98.
This also notice. 99.
99.
Delay of 689 days condoned on condition.
Maybe refer to Adalat.
Huh?
Maybe refer to Adalat.
Refer this matter to the Lok Adalat. 100.
100. 100. 100. Pankajappa.
Yes, 179 days. 179 days delay, condone, admit final hearing TCR, 101,
106, 101, FS Dabali,
86 days, condone, admit final hearing TCR,
number 102,
473 days, condone on condition, final hearing TCR, 103,
103, Girish B. Baldare,
31 days, condone, memo for dispensation to R1 dispensed with, then R2 is Cholamandalam.
Cholamandalam Insurance.
Mr. Pradeep is directed to take notice on behalf of the insurance company, admit final hearing TCR 104.
104, E. Chandrasekharaya,
Appellant, my lord. Represent the second respondent. Electronic copies and file wakalat.
844 days delay.
No, I'll file my formal objections because there is 844 days.
That's anyhow on condition.
Well,
844 days. Give him the papers. 844 days on condition, admit final hearing TCR.
105, Gurdev Prasad,
For the respondent, my lord.
49 days delay, condone, admit. 106.
Call for records. Call for records.
It will be Mr. Vijay Kumar. 106.
106, Suresh R,
191 days, condone, on condition, admit final hearing TCR. 107. 199 days delay, condone. Yes, this is New India.
India Assurance,
New India Assurance Company. In 107.
107, my lord. I take notice.
AMN.
You take notice for new. Mr. A.M. Venkatesh is directed to take notice on behalf of the insurance company, admit final hearing 108.
108, B. Chandrasekharaya.
My lord, I appear for the respondent. I have filed my objections, my lord. Yes.
Yes.
More than 7 years delay, my lord, in filing the application.
1,657. In this,
Plus 2 years of COVID period.
the,
My lord, the appeal is of the claim petition is of the
I'm giving
2013.
you time, Mr. Venkatesh.
I filed objections.
You have already filed.
I already filed.
Give that. II 1 of 25 is filed to condone the delay of 1657 days delay. Then counsel appearing for the insurance company has filed the objections. Ultimately, even if there is delay, for that period, as this court is condoning the delay on condition, there cannot be any prejudice to the
But from date of
respondent
petition should not be interest. There should not be any interest.
for the respondent. Hence, the respondents are not entitled for interest from for a period of 1657 days. Yes,
Till number 109.
the accordingly delay is condoned, admit final hearing TCR 109 days.
109, till number 109.
75 days delays.
Notice to the respondent, next content.
Cell number 110, K. Prasanna Shetty,
I number 1 of 25
Respondent
for the
two
condone the delay of 20 days, condone, admit final hearing TCR.
But we have not received the
Okay.
copies.
Huh?
We have not received the copies, my lord.
Then 110 for dismissal tomorrow, don't pass any order. Yes, 111.
till number
I
111,
am for the appellant, amount rupees, my lord, 2,50,000 deposited before the tribunal, my lord. I am going to produce the acknowledgement.
That the amount is deposited before the court. I number 2 of 25 is filed to condone the delay of 4 days, condone, admit final hearing TCR 112.
112, Chandrasekharaya,
331 days, condone,
till number 113,
For respondent, madam.
91 days, condone,
till number 114,
60. What about this?
47.
Notice filed seeking dispensation of notice. to
R2
R1
National
dispensation.
Insurance Company. R2 National Insurance.
National.
Geeta Raj is directed to take notice on behalf of the insurance company. I number 1 of 25 to condone the delay of 63 days, condone, admit final hearing TCR 115.
Till 115, Sushmita,
I number 1 of 25 to condone.
Malad, one submission, Malad. I have filed the application withdrawal of the amount, not yet put up, Malad. Kindly out next week, Malad.
I number 1. What is this? This is a case of death or injury?
Case of injury, Malad, amputation,
I number
Malad.
1 of 25 to condone the delay of 46 days, condone. This is admit post for final hearing. Call this matter on 20th.
Much obliged.
till number 116, Veena Rangegowda,
56 days delay, my lord.
Admit final hearing. This year.
117,
17, my lord,
Veena Rangegowda,
United India General Insurance Company served, my lord.
Take notice, my lord, for United Kingdom.
So A.M. Venkatesh is directed to take notice on behalf of the insurance company. Delay of 128 days condoned. Admit final hearing.
118, Kevin Nayak.
58 days condoned.
I'll have next week, my lord.
What is this?
Actually, for second husband injury case, my lord, we'll negotiate, my lord. Next week, my lord, we'll report. Before
20th.
lodge.
20. Serial number 119.
For the respondent, my lord.
Girish
Delay may be-
Condone the delay in 118, but it will come up next week. Case 119.
119.
For the respondent.
IA number 1025 to condone the delay of 199 days. Condone. Admit final hearing.
Then for admission matter 120.
Admit final hearing TCR
Serial number
121.
121.
What is this? IA number 3 for?
My lord, in IA 21, the IA for impleading may not survive because it appears some advocate has filed the power. The cause list says so, one Mr. Bhatt.
The branch manager Bhargav B, but for R1.
Mr. P. Ravishankar is directed to take notice against R2. Appeal is dismissed against R1.
R1.
R1. Then no, not in
No,
this
no,
matter.
not R1, because R1 is the,
New India. So for R1, R2, who is this R3? That's what I'm asking.
no. R3 was another insurance company who were deleted before the court below. Therefore, I sought the implement of New India Assurance Company before my lord.
Oh,
And your lordship condoned the delay and ordered issuance of notice.
1 minute. In this case,
Yes,
already first is 1 and 2 are the respondents.
yes.
1 and 2 are who?
Two is New India.
New India Insurance Company.
Yes,
Now,
yes.
who is the impleading is for
No,
whom?
no, we wanted them to be impleaded because the office raised an objection, my lord. We were compelled to implead that earlier.
New India Insurance Company was not there
No,
before the court.
No, the Oriental was there,
Hmm.
who were deleted. And therefore, the office here raised an objection. They were deleted. How can you make them a party? For that reason, I made New India Assurance.
That is submitted that the vehicle is insured with New India Insurance.
Yes.
And New India Assurance has that so and so is a necessary party. Accordingly, I number 3 of 24 is ordered. The petition shall file the amended copy. The Mr. for the New India Insurance Company, Mr. Just now I said some name, P. Ravishankar is directed to take notice. Yes, admit fund hearing TCR. 122.
122.
Meanwhile, my lord, the stay is the short date, my lord. They are pressing for execution. That's the reason.
List the matter on 20th. 122.
Serial number 122. Prashant BK.
Admit.
Serial number 123.
Appearing for the respondent, my lord.
The appellant.
Case of injury, my lord.
Admit.
Please.
Yes, right.
Any date maybe?
We have so many matters. We'll see. Admit final hearing TCR. Yes,
124.
124.
Syed Abdul Sabur.
Appellant.
Notice. 125.
Serial number 125.
Admit final hearing TCR. 126.
In this matter, my lord,
25.
they are disputing only liability, my lord, pain recovery.
Apply.
Yes, my lordship.
So 125 pass over.
Yes, ma'am. In charge.
126.
126 Vijay Kumar
26.
T.
TCR may be called for me.
Admit final hearing TCR. 127.
Serial number 127. Take
I for the respondent.
10% contributory negligence has been recorded, my lord. It's a case of kindly TCR may be called.
Admit final hearing TCR. 128.
128.
I prefer.
Kikan Rao.
Admit final hearing TCR.
Serial number 129.
Soft copy received, my lord.
Admit final hearing TCR.
130.
Refer to local law.
Would be
Matter may be referred to Lok Adalat.
Dalat. 131.
131.
For the responding.
Huh?
FS Dabali.
Non-depositing of the amount.
Why?
But there is some 25 lakh and odd more.
We will start with your case, Mr. Dabali, vacating the interim orders for not filing this because this was on 13/8/2025, 4 weeks time. When it will complete?
Some 10 days time, order.
In 131, list this matter after a week. By the time if the memo is not filed stating about the deposit of the amount as per the interim order, The stay granted by this court stands vacated without further reference to the court.
132, G. Ravishankar Shastri.
For second respondent.
My lord, it is a case of injury.
Served, papers are served.
Served.
Case admit file nearing TCR 133.
133,
Admit file nearing TCR 134.
34,
My lord, in
Giri.
134, my name may be deleted, my lord.
Delete the name of Mr. Vijay Kumar.
In
Yes.
this case, matter may be disposed of. Yes.
What is this about?
It's a case of injury, my lord.
Loss of future.
Yes.
In this case, loss of future earning is not considered. The court has come to the conclusion in para 33.
There are about 4 matters.
Wait.
Para 35 minutes there.
No, no, 134, 135 code. Yes.
134, sir.
Yes, yes.
134.
134.
134.
How many?
Court has come to the conclusion
Where is the
that
table?
35 minutes.
para 35.
How many are the injuries?
6 fractures.
What do you say, Pradeep?
75,000 has already granted, my lord.
So 6 fractures.
My lord, that-
41.
that's my lord, inferior pubic remi, my lord. My lord, friend saying including that, that's the only one fracture, my lord.
So how many it will become according to you?
My lord, clavicle fracture, pubic remi fracture, and iliac fracture, my lord. Four fractures.
Vertebra fracture is also
Sir,
there. Clavicle fracture.
4 fracture only.
Multiple fracture of ribs.
4, my lord.
Total
4.
75 rightly granted, my lord.
Another 5,000, 80. Next,
La-
medical expenses.
as per bills awarded. Loss of future earning is
1 minute. Come to the table. Incidental,
12 days inpatient.
how many days?
12 days. my lord.
12 days he was in.
Already it's granted, nothing. Next, loss of income during later period.
6 months is considered.
6 months, my lord, 16,500 as I consider.
99,000. Then where he wants,
Loss of
Here, my lord, the MSCT has granted compensation in later period and amenities more because the loss of future earnings has not granted. Was aged about 55 years, my lord, is said to be a mechanic. Afterwards, whether
the doctor was examined?
yes, my lord.
What is the evidence of the
Para
doctor?
Para
Doctor assessed, my lord, 90% upper limb
upper and lower limb.
and
Then
lower
why
limb. my lord.
why the multiplier is not adopted?
The MSCT,
So what we do is, if the multiplier has to be adopted, and under the other heads, we will correct it. So for example, incidental expenses, how many days he was in hospital?
12 days.
12 days.
So we will grant him 12,000.
Please.
Then coming to the loss of income during the later period, we will
3
grant
months.
about, how much is the income?
12 days,
16,000.
3 months, my lordship.
Yes. Into 3, 49,500. Now, coming to the loss of future income.
Future.
So as per the evidence of the doctor, how much it should be?
90%
whole body.
the whole,
90%.
whole body.
Upper limb?
Upper limb and lower
Upper
limb. both
limb
include-
and lower limb, both are including 90%.
No, what is upper limb? What is lower limb?
There's no bifurcation. Doctor stated that lower and
90%.
upper limb is
Straight away, they said, well, 90% to the both lower limb and upper limb. They are not
Okay.
bifurcated.
So, because it is 1/4 and 1/3,
The doctor himself has stated that 26% to the whole
1/3.
body.
26%.
26% to the whole body. The MACT coming to the conclusion, my lord, it is extracted in para 33.
Para?
33.
33, come to the conclusion that he is entitled for the loss of future earnings. While computing the compensation, no amount is awarded.
So how much should be taken?
She may consider 20%.
So, 16,500 into 12 into, what's the multiplier?
11.
11 million, 55 years,
11 into
20%.
20 divided. by-
Future perspectives to be considered.
After, that's why he said cleverly 20.
4,35,600.
It comes to 4,35,600. Then amenities, how much is granted?
55 years.
55,000
Amenities is,
is on the lower side.
it's not on the lower side. We will take 50,000 as amenities.
6,59,780.
Please come. Agreed with the award passed in MVC number 3161 of 2024 dated 25th April 2025 by so and so, the Chief Justice so and so. The claimant is before this court seeking enhancement of the compensation. Next para. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by the claimant in the accident. The tribunal has awarded the compensation as per the table given below. At paragraph number 39, extract this table. When counsel appearing for the appellant claimant submits that when the claimant has sustained 4 fractures under the head of pain and suffering, the court has not granted a reasonable compensation. It is submitted that when the doctor has opined that he has suffered 90% disability to the limb and 26% to the whole body, court has not granted any amount under the head of loss of future income. It is submitted that on all counts, the compensation that is awarded by the tribunal is not just and reasonable. Next part. When counsel appearing for the respondent, insurance company submits that the doctor had deposed that the disability to the upper limb and the lower limb is 90% and whole body is 26%. It is submitted that there should have been a bifurcation. If it is, as far as upper limb is concerned, is 1/4 of the whole body is a disability, and if it is lower limb, it is 1/3. And the court had rightly not taken has not granted any compensation. It is submitted that as the court has not granted compensation on the head of loss of future income, under the head of incidental expenses, loss of income during the later period, loss of amenities, court has granted amounts on the higher side, and the same needs to be reduced. Next part. Having heard the counsels on either side, peruse the material on record. Next. Considering the injuries that are sustained by the claimant and the head of pain and suffering, this court is granting 80,000. Medical expenses, there are no medical expenses, no interference is called for. He was in hospital for 12 days. Hence, at the head of incidental expenses, this court is granting 12,000. Coming to the loss of income during the later period, the court had granted for 6 months, which is on the higher side. Hence, this court is granting for 3 months, that is 49,500. Coming to the loss of future income, as rightly argued by the legal counsel appearing for the insurance company, the tribunal, the doctor ought to have deposed about what is the upper limb disability and what is the lower limb disability. Unfortunately, the same was not done. In these circumstances, this court is inclined to take the disability at 20%. Hence, under the head of loss of future income, 16,500 into 12 into 11 into 20 by 100 is 4,35,600. Under the head of amenities, this court is granting 50,000. In the light of the law laid down in Mekala versus so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for 6,59,780. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 2,76,680 to 6,59,780. The enhanced amount shall carry 6% interest. Any delay?
No.
Delay.
No delay.
Delay.
Huh?
No,
No delay.
Not it. Part
Yes,
of matter, serial number 135, Ashok N. Patil for appellant.
Respondent, claimant, my lord. My lords, one indulgence, if I may be permitted. My apologies, my lords. I missed 91. It may kindly be put up tomorrow, my lords. I will not. My apologies.
It is passed over.
Passed over. Please, my lords. I'll.
Yes, next.
Minutes 135 minutes. There are 4 matters where minutes we have challenged liability on the ground that minute the driver of the
Quantum is involved now.
quantum minutes. I have also questioned quantum on the ground that minute the driver of the offending vehicle minutes who was holding a learner's license did not accompany with any person who was holding minutes a duly and valid license. And that is the minutes point I am urging minutes. We have adduced evidence and RTO has also minutes deposed that. Initially, what happened was
that apart, like that's offending vehicle. You mean?
Yes, which is insured with me. Initially, the charge sheet was filed under section 3(1). After filing of the WS, he has filed the driving license. Driving license. One of the condition is that
if he is holding a LLR driving license, it is necessary under Rule 3 of the Central Motor Vehicles Rules that he should accompany a person. According to us, there is
latest judgment of Justice Narasimha, Justice Narasimha,
Yes,
where there was no driving license at all. Still they said, like that's how referred to Swaran.
pay and recover may be applicable. Here, owner is also contesting. But once he is before the court,
that I will, that
it is not for him.
ultimately, even if he is before the court.
Yes, ma'am.
But we are looking at the interest of the third
Yes,
party.
ma'am.
As far as he is concerned, the pay
Now,
and recovery
no
will
pay and
apply.
recovery is made. My
That
endeavor
we will-
is
that
that
we will-
if
that we will do.
even
What
there
do you
is
say?
breach of.
Kindly pass on, but he lives in other court.
Yes, password. Password, madam. That passwords you call.
The passovers matters in list number 1, till number 11.
Correspondence.
Case of death, my lord.
Where is it? Where is the table? What is wrong
Page
with the
page 11 of
calculation?
the judgment.
Huh.
Page 11 of the judgment.
Page 11.
11,983 is taken, my lord. 2022.
Which year is the accident?
2022, my lord.
And how much is taken?
11,983 is taken, my lord. 15,500 is now, my lord, taken.
22 is 15,500. Court had taken 11,000?
983, my lord.
11,983. Then with regard to future prospects,
10%.
10%, my lord.
was taken.
Taken, ma.
All other things has been granted.
Multiplies 11, my lord, 54 years, my lord.
How many are the dependents?
Wife and children, my lord, 1/3 is deducted, my lord.
Wife, 2 children.
1/3 are already deducted.
3.
So 15,500. It's 16,550 into 1 divided by 3 is 5516 minus. It comes to, his income is 11,000. His income is 11,034 into 12 into 11.
11, my lord.
It comes to, loss of dependency will come to 14,56,488. 44 into 3 is
1,32,000 given, my lord.
1,33,000.
32 money.
32,000. Then 36,000, 10,000.
My lord, loss of dependency come to 15,444.
How?
10%.
10% future.
No, that's what.
15,500 into 10%.
That's what 15,500 is 1550 is 16,550.
17,000.
1 minute. Oh, I must have taken 15,000.
15,500.
1 minute, 550 plus. Correct. 17,100 minus 5516.
Minus 5683, my lord, 1/3.
17,100 into 1 divided by 3 is 5,700. 17,100 minus 5,700. It comes to 11,400 into 12 into 11. 15 lakhs, 4,800. Plus 1,32,000 plus 36,000, 10,000. It's coming to 16,82,800. Agreed with the award passed in MBC number 864 of 2022 dated 5th January 2024 by the so and so. The appellant is before, the claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 69,50,000 for the death of the deceased in the accident. The tribunal has awarded the compensation as per the table given below at paragraph number 70, extract. Learned counsel appearing for the claimant submits that the accident has taken place in the year 2022 and the court had taken the income at 11,983. The court ought to have taken 15,500 as income and ought to have granted the compensation. It is submitted that on the head of loss of dependency, the compensation needs to be enhanced. And even in the other conventional heads also, the amount that is awarded is not just unreasonable. Next one. Having heard the counsels on either side, peruse the material on record. His contentions, learned counsels are for the respondent insurance companies of Mr. Either the tribunal has granted a just and reasonable compensation. No enhancement is called for. Next, having heard the counsels also, peruse the material on record. This accident had taken place in the year 2022. When there is no evidence on record, as there is no evidence on record with regard to the income, this court is taking the income as per the chart prepared by the Legal Services Authority, and the income is taken at 15,500. The age of the deceased is
54.
54, and future prospects at 10% would come to 1,550. That is 17,100. 100, and there are 3 dependents. 1/3 has to be deducted. It comes to 5,700. Then his contribution to the family would be 11,400 into 12 into 11 is 15,04,800 towards the consortium. 144 into 3, 1,32,000. 36,000 towards funeral expenses. In the light of the law laid down in make allowances and so legal expenses 10,000. Altogether, the claimants are entitled for an amount of rupees 16,82,800. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from an amount of rupees to 13,24,969 to 16,82,800. Any delay in this? It is confirmed, yes. According, the enhanced amount shall carry 6% interest.
Number 22, Kailash Shankar.
Yes.
Take case of death, my lord. In this case, there is no DL. There is no DL. The tribunal passed liability against the owner of the vehicle. And we
Notice
have
is served on the owner of the vehicle?
Yes, place expertise before tribunal, my lord.
Yes.
And we are also challenging, seeking enhancement also. This case, a case of death.
What do you say, Mr. Vishnu?
My lord, as far as pain recovery orders are concerned, I may bring it to my lord's kind notice only 2 points. It will take only 5 minutes for me. Para 4 of Swaran Singh's case, they considered only 4 points.
Latest judgment of Justice Nasimha. Yesterday I've considered that and passed one order where, what's her name? Tejasvi. She argued and she placed some judgments of Justice Hanchade Sanjay Kumar, Satnarayan Murthy and another division bench judgment. In the similar line she argued. Then I found the judgment of Justice Narasimha where it's a case of no driving license. Pain recovery was not ordered. They have ordered, they have considered Swaran Singh and they said so. Ananta versus something Venkatesh.
If Supreme Court has considered Swaran Singh's case, therefore question of arguing.
Yes.
My lord,
So come to
further liability need not be imposed on me by enhancing compensation because this is also a case of pay and forget.
Yes.
There are 3 dependents, my lord. Tribunal.
So amount is taken as?
Amount is taken as 12,500.
12,000?
Income is okay. But regarding dependency, woman, there are 3 dependents. There are 3 dependents. Tribunal deducted 50% instead of 1/3.
That's the only thing. What is his age?
50 years.
58.
50.
Age of claimants. Only thing that I can press for this is both are majors, 33 years, 34 years and 33 years.
Girls
Ages.
or boys? Again,
Both are sons.
32, 33, then the judgment, the latest judgment of Justice Prashant Kumar Mishra,
Seema Rani and others. Yes.
13,750.
ಬೇಕಾಗಿಲ್ಲ scope. Interest ಎಷ್ಟು?
What is the multiplier?
13 well.
Judgment ಕೊಡು.
It comes to 14,30,000. How, you said 3 dependents.
Please, ma'am.
1,32,000. 36,000, 10,000.
ಇದೆಲ್ಲ rate of interest.
Interest 9% ಮಾಡಿದ್ರೆ.
That we will reduce.
Please.
That we will reduce.
That extent saved.
It's coming to 16,08,052 against
delay ಇದ್ದಿದ್ದು.
11 lakh. Any delay?
954 days delay.
Award is 13,75,672 my lord.
No, no. The award is 11,32,000.
After adding 25% future price, right? That's come 13,75,672. Para number.
Why 25% future price?
Can you see the para number?
No, no, no. I'm looking at the table at page 30.
After the tribunal consider first table, then they have added the future price.
We will look at only this 11,32,000. I think.
Kindly see the para number 24.
Whatever it is now, the amount is 16,08,000. The agreed with the award passed in MBC number 7096 of 2019, dated 18th of January 2022 by so and so. The claimant is before this court, questioning the liability fixed on the owner of the vehicle, as well as seeking enhancement of the compensation. The tribunal has held that the owner of the vehicle is alone liable to pay the compensation on the ground that there was no driving license to the driver of the offending vehicle as on the date of the accident, and the burden lies to pay the compensation on the owner. The owner of the vehicle has remained absent, and no efforts are made by the insured to prove that there was no breach of terms and conditions of the policy, and the insurance company is liable to pay the compensation. Hence, the court has held that the RC owner and driver of the offending vehicle shall pay the compensation amount. When it comes to the compensation, the tribunal has taken the income at 12,500, but deducted 50% and granted the compensation. Land counsel submits that when there are 3 dependents, court ought to have taken 1/3 as the dependents, or 1/3 should have deducted 1/3. It is submitted that in the judgment of the Honorable Apex Court in Seema Rani's case, the Honorable Apex Court has considered the major sons as the dependents. Next paragraph. Land counsel appearing for the insurance company submits that in the light of the law laid down in Swaran's case, having no driving license amounts to fundamental breach of the contract. As such, the question of pay and recover will not arise. Next paragraph. Land counsel further submits that the court had considered 25% future prospects when the age of the
50 years.
When the age is 58 years, it is submitted that no enhancement, and it is submitted that in fact the amount has to be reduced and the no enhancement is called for. It is further submitted that the children who are aged above 30 years cannot be considered as dependents, and court has rightly taken 50% has deducted 50% towards the, has rightly deducted 50%. It is further submitted that the interest is awarded at 9%, which is on the higher side, and the same needs to be reduced. Next paragraph. Having heard the counsels on either side, there is a material on record. First, coming to the aspect of liability. Consistently, from the judgment of the Swaran Singh and in the several judgments of the Honorable Apex Court till the latest position, consistently the courts are applying the principle of pay and recover, and this court cannot be an exception. Hence, the principle of pay and recover will apply. In this case, the notice to the respondent owner of the vehicle is dispensed with on a memo filed by the claimant, as he was ex parte before the trial court. Then coming to the quantum, as rightly argued by the learned counsel for the petitioner appellant, in the light of the law laid down in Seema Rani's case, that citation you will get from the PS. Seema Rani's case, they cannot be, the court ought to have deducted 1/3, hence taking the income at 12,500. Future prospects at 10% comes to 1250, that is 13,750. And if 1/3 is deducted, that is 4,583. The contribution to the family would be 9,167 into 12 into 13. Under the head of loss of dependency, it comes to 14,30,052. Then towards consortium, 1,32,000, funeral expenses 36,000. In the light of the law laid down in Mekala, 10,000. Altogether, the claimants are entitled for an amount of 16,08,052. Accordingly, the appeal of the claimant is allowed by enhancing the compensation from an amount of rupees 13,75,672 to 16,08,052. The entire amount shall carry 5% interest. And this is which case? 16? 22. A delay was condoned, 954 days delay was condoned on condition they are not entitled for interest. Hence, for 954 days, the claimant is not entitled for interest.
Cell number 47.
Case of injury.
Forty-seven. Yes. Where is that calculated, Pradeep?
Please, there are 18.
Take that. Para 18. So, pain and suffering as it is.
Please.
Medical expense. Then at the conveyance food
attendant 3,000.
3,000. Loss of income during the later period. Court has considered only 1 month.
1 month 14,000.
14,000. Now it is 3 months.
Please.
Income should have been 15,000.
Please.
Then medical expenses as it is. So loss of future income, how the court has considered?
14,000 into 6.66%.
Into 12 into?
Into 12 into multiplier wrongly
13.
adopted, my lord.
Multiplier should be 13.
Instead of 13, my lord, 11 has been taken. 48 years.
So now it should be 14,000.
15,000. MSCT considered 14,000.
It should be 15,000.
It should be 15,000.
15,000.
Right side column I have mentioned.
15,000 into, as far as the disability concerned, no issue.
No issue.
So 15,000 into 12 into 13 into 6.66. It should have been taken 7.
6.66.
Already it's crossing 6.55.
20% to the left lower limb, my lord. That's what, my lord. The MSCT record.
It comes to, no, it should have rounded about to 7.
Then, my lord, calculation varies. I have already calculated on that. I have mentioned in that.
So we'll take it that way. 15,000 into 12.
Amenities only
1 minute into 12 into 13 into 7 divided by 100. It's coming to 1,63,000. Hardly difference is 9,000. Isn't it?
Yes, ma'am.
Minus 1,54,400.
No, my lord, minus 1,21,000.
Huh?
MSCT granted 1,00,000.
No. Your calculation is 1,54,400.
Yes.
My calculation is 1,63,800. So in the entire amount, we have to deduct 9,400. That's it. So then coming to the loss of future earning, it is amenities. Where is it?
First one.
Amenities is 20,000. For the
10,000,
disability,
another 10. 3 days inpatient, that's
it
what
can be another 10,000. So 30. So it has to be 19,400 addition to your calculation.
Please.
So it is 3,54,103. You have added 10 also. Plus 19,400. It's coming to 3,73,503. Yes, please come. Agreed with award past 10, MBC number 1423 of 2021, dated 15/3/2023 by so and so. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 18. Extract that. Then counsel appearing for the claimant submits that on the head of loss of amenities, loss of income during the later period, and loss of future earning, the court has not granted a just and reasonable compensation. It is submitted that the court had taken the income at 14,000 and the accident had taken place in the year 2021. Court ought to have taken 15,000. It is submitted that on all counts, the compensation that is awarded by the tribunal is not just and reasonable. Next paragraph, counsel appearing for the respondent insurance company submits that the court has granted a reasonable compensation and there are no grounds to interfere. Next, having heard the counsels on either side, peruse the material on record. First, coming to the head of pain and suffering, the court had granted a reasonable amount and no interference is called for. For the food attendant, as he was in 3 days in hospital, court has rightly granted 3,000. Coming to the loss of earning during the later period, considering the income at 15,000 for 3 months, this court is granting 45,000. Medical expenses as it is, no enhancement is called for. Then coming to the loss of future earning, according to the doctor, it is 6.66%. As it is 6.66%, this court is rounding it off to 7%. Hence 15,000 into 12 into 13 into 7%. It comes to 1,63,800. 63,800. Then under the head of amenities, this court is granting an amount of rupees 30,000. In the light of the law laid down in Meghalaya, 10,000. Altogether, the claimant is entitled for an amount of rupees 3,73,503. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 2,70,671 to 3,73,503. The enhanced amount shall carry 6% interest. 10. This court has condoned the delay of 683 days on condition, and the appellant is not entitled for the interest for the 683 days. Yes.
Serial number 91.
Serial number 91.
My lords, I appear for the petitioners in this matter. That is the claim petitioners. My lords, they have filed an application for release of the amount. My lords, 50% is deposited before.
It's a case of death, you said. It's a case of death. I'm disposing the appeal itself.
My lords, if it can be taken tomorrow, my lords, I'll come personally address. My lords, there is
no, it's not required. So you just watch the proceedings. If you feel that it is required, you can come tomorrow. We'll then accommodate.
My lords, in fact, we wanted to file a cross objection, my lords, on that, regard, because she has met with.
Just wait. Without you filing anything, we will take care of it. Yes, what is the ground for you on quantum? On quantum. Please tell the detail. We'll not go into that. How much is which year is the accident?
The accident is, my lord, in the year of 3/2/2020, my lord.
2020. So 14,500.
14,500.
What is the age?
MSCT has considered 20,000, my lord. That's why I am questioning.
And then how can it be 20,000? Is there any evidence for that?
Yes,
My
my
lords,
lord.
there are evidences, my lords, lot of evidences have been placed on record. My lords, I may be permitted tomorrow, I'll come, my lords, I'll try to raise.
Yes, not tomorrow, next Thursday.
My lords,
This is matter next Thursday. Yes, next.
my lords, meanwhile, for release of that amount, my lords.
No, 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 for 1 week, we will not do that. Again, sending the TCR. Yes,
Please,
next.
my lord, please.
List number 2, final hearing matter, serial number 1. Ashok and Patil.
This is the appeal filed by the insurance company.
On the ground?
Liability, my lord.
On the ground.
Yes, my lord. On the ground of liability, my lord. The insured.
Why you are denying the liability? That's
My
what
lord,
is the question.
the petitioner himself was riding the motorcycle, self-fall, my lord, and sustained injuries, my lord. And my lord, accident has taken place on 21/12/2015, my lord. They have filed a complaint on 9/1/2016, my lord, after lapse of 19 days, my lord. Immediately after the accident, they are admitted to the Chamrajnagar Government Hospital, my lord, wherein the document clearly discloses that self-fall from the bike, my lord, which will be marked as Exhibit R4, my lord.
Judgment is in Canada.
Yes.
This is matter in the month of January.
Next week, my lord, I'll file. Next week. Next week, my lord.
This is matter next week on Thursday, provided the translated copy
We'll
is
file
filed.
it.
This is matter on 11th of December. By that time, the translated copy shall be filed, or else the matter shall not be listed.
Macho.
Serial number 2. J. Kumar T.
Yes. Where is Mr. Samprati?
Ravi Sampath.
Yes.
Case of death, my lord, the income taken by the tribunal on
Which year is the accident?
accident, my lord, 2018, my lord.
2018 is the accident.
My lord. As per exhibit, my lord, salary certificate, 31,000.
31,000. Court has taken?
17,500, my lord.
Please come to that.
My lord. Para number 16, my lord. In page 12 of the judgment. According to petitioner, at the time of accident, the deceased was just 30 years old and had monthly income of rupees 50,000 by working as mechanical engineer in Major Sonu Vision, Whitefield, Bangalore. The petitioner has produced salary slips and bank statement of his deceased son at exhibit P18 and 19, in which in the basic salary of the deceased is rupees 17,500. Further, the petitioners have not placed and not disclosed that the deceased was in income tax payee.
So rightly taken 17,500 is the basic.
My lord, basic salary was taken, my lord.
What are the other things?
My lord, as per exhibit P19, my lord, the bank statement disclosed that, my lord, per month more than 30,000.
Oh, that there should be evidence for that. What is that 30,000 you are getting? Under what category? If they are
My lord,
like,
I have,
no, if they are variable components, that cannot be considered.
my lord, I have examined the
They said that
PW2
17,500 is
employer,
your
my lord.
salary. Paragraph number 16, continuation, second para.
Please, my lord, please, my lord.
The HR manager of Sonu Vision Company.
Has been examined as PW2 under
The basic salary was 17,500.
basic salary has been taken, my lord, instead of grass salary, my lord.
What are that? That we have to know.
My lord,
What
as
are the
per
components? For that, there should be a salary slip.
please, my lord.
On the
As per
salary slip, what are the components?
my lord, exhibit of P17 and 18, my lord.
Take that.
The other components are HRA, conveyance, LTA, and medical.
My lord, every month, my lord, the salary credited to the bank account, my lord, please.
Where is it? Where do you get it? Next. So 17,500 is the basic. House rent 7,000. Conveyance 1,600. Medical reimbursement, leave, travel allowance.
City compensatory allowance, 3,169.
So what has to be deducted from this?
My lord, 7,000 towards HRA, that can be added.
So why is it has to be deducted from the salary? No. Isn't it?
Yes, ma'am.
It shouldn't be. Then
The other conveyances.
only any statutory other things are there that we need to. Remaining we cannot.
The thing is conveyance and LT.
Let Sampriti, Mr. Sampriti come pass over this matter.
Cell number 3.
Yes.
Cell number 3.
Pass over.
Cell number 4.
You are there?
Yes, Harish Anna.
Yes.
Praxi counsel, my lord, 1 week time may be granted, my lord. He is some emergency, he went to the office.
It's a case of injury.
Yeah, both cases are injury cases.
We can decide.
Praxi counsel.
This is matter in the month of December. It's for.
Cell number 4.
Claimant respondent.
Ready. For the appellant, my lord. Not the appellant, my lord, is the.
What is this?
My lord, in
What
this
is
case,
the-
Yes.
your lordship permitted the claimant to withdraw the amount, my lord. And learner friend filed an IFR recalling, my lord.
Lord,
No, we will hear. That's what it
yes,
is.
ma'am.
It is.
Yes.
Yes. Where is the appeal? I mean, the table. It's a case of death or injury.
My lord, it's a case of death, my lord. The appellant is the owner of the vehicle, my lord. And the claimant's respondent, my lord, filed
Placing under ECA.
ECA, yes, my lord. So, my lord, they filed a petition under section 3 of the Workmen's Compensation Act, my lord. My lord, on appearance of the appellant, my lord, before the trial court, he specifically raised the dispute regarding, my lord, that vehicle was not involved in the accident. This is the first contention, my lord, taken by the appellant herein. And there is no jural relationship of employer and employee. This is the specific contention, my lord, we have the appellant has taken before the trial court.
Let us see come to what are the averments of this petition? Employed as a coolie under respondent number 1.
Yes, my lord.
Who are you?
I am the appellant, my lord.
Owner of the
Owner of the.
Coolie under respondent number 1 in his tractor trailer.
Yes, my lord. My lord, the reasoning is at para number 10, my lord. My lord,
Who is PW2?
My lord, PW2 is the father of the deceased, my lord, person Rangachari. And my lord, admittedly, my lord,
Ramegoda is the owner.
Ramegoda is the owner and the appellant before this honorable court. My lord, there is no eyewitness to the incident, my lord, accident. They admit that, my lord, they are not the witness to the accident. And even in the criminal proceedings, my lord, the Honorable Criminal my lord, Trial Court, my lord, after appreciating the entire material on record, held that, my lord, there is no eyewitness to the incident, and even the prosecution of failed to prove that the appellant herein was the driver of the tractor and trailer, my lord. That is the, my lord, it is not the benefit of doubt which has been given by the
That's what-
trial court.
Because it's beyond reasonable doubt.
Yes, my lord. But even before this honorable court, before the trial court in this workman's compensation proceedings, my lord, no eyewitness is been examined. My lord, when we have disputed the, my lord, the involvement of the vehicle, and so also, my lord, the jural relationship of employer and employee, my lord, some.
Come to
Yes.
paragraph number 12.
Yes, ma'am.
There in the.
Yes, my
in
lord.
Kannada.
My lord, that is only a stray sentence, my lord. I'll just
Whatever
read
is the
it.
sentence,
Yes,
is a
ma'am.
sentence.
I'll read it, my lord. ಮೃತ ಕುಮಾರಾಚಾರಿ ನನ್ನ ಬಳಿ ಕೆಲಸ ಮಾಡುತ್ತಿರಲಿಲ್ಲ ಎಂದ ಸುಳ್ಳು ಹೇಳುತ್ತೇನೆ ಎಂದರೆ ಸರಿ. Lord, that is the it is in Kannada. Lord, if we translate it, it says that, my lord, it is true to say that I am deposing falsely. I am deposing falsely before this court that deceased Kumarachari was not working under me. My lord, there they have mentioned this sari illa. My lord, ought to have mentioned typed as sari illa. My lord, if we see the entire case.
What is the other evidence to show that the deceased was working with the appellant?
The appellant has specifically admitted that
It is not an admission. It is like, it is not right to suggest, it is not true to say, that's kind of the one. When it is a specific plea, when it is, please understand, when it is specific plea in the entire pleadings, in the entire evidence, that there is no dual relationship of employer and employee, where is the question of.
Not true that, madam. They have taken specific contention, but not to prove it. And apart from that,
They should not
I have
prove.
issued a legal notice. I have issued a legal notice after the accident, but they have not issued any reply notice to.
No, apart from that, there should be, when there is a specific case and they are denying the relationship, the burden lies on you to prove that whether there is a relationship or not. And whom you have examined. You should have examined somebody in your village, in your place, who says that you are working with him.
Lord, I examined the deceased.
That's your father.
Wife, my lord, and
You're not your family members.
Materials also charge filed against the appellant, my lord. But they have not questioned the.
No, that has no concern at all. No, it is under ECA. First of all, it's about the relationship. It is not about whether the accident had taken place or not. Because according to you.
The accident taken place, my lord,
We'll accept it. The accident had taken place. The accident had taken place. Now, what are you doing there? According to you, you're a loader and unloader, coolie. That has to be established. And that too, when you filed a petition under the section 3 of the ECA. So wait for your withdrawal. Not a good day today.
Considering
List is matter.
subject to result of the appeal, my lord.
List is matter on in the month of December.
Any date may be given. The
I can do it
accident
today
will be
also.
16, my lord.
No, you please understand. I can do it today also. I don't want to do it. So unnecessarily giving a date is not good. Take it in the month of January. List is in the month of January.
My lord, one more aspect, my lord, they have asking for settlement. That attitude, my lord.
My lord, kindly appreciate, my lord.
That is off the record.
Off the record, my lord. Kindly appreciate, my lord. I had.
How much the appellant is
My lord,
ready to pay?
My lord, the total. My lord, the total award amount is, my lord, 6,75,000.
You're ready to pay?
My lord, I have proposed 6,29,000 in dot. My lord, I said, my lord, off the record, my lord, I said, you take the principal amount. Take the entire principal amount. My lord, because I don't want to, my lord, again, my lord, if I am liable to pay the interest part, my lord, it will be almost double. That is the reason.
It's a good offer.
my lord, they have not even proved any, my lord, the involvement of the vehicle
Please,
as well as.
please advise your client to take it. Ultimately, you will not succeed in this. So for example,
10 lakh.
if the petition itself is dismissed, what will you do? That's why I'm saying take January. If he's coming up with that amount, you better accept it.
My lord, I have already deposited that amount, my lord. If they are ready, then I have.
Next Wednesday, my lord.
List the matter on next Wednesday.
Thank you.
Get instructions.
Bill number 5. Marigowda,
Respondent,
PS Jagdish,
yes, of death, my lord, in this matter, my lord.
Injury.
Death, my lord. The only ground they're challenging is the dependents are married daughters and grandchildren. Two married daughter and their
How
children.
old are they?
My lord, they're 30 and my lord, tribunal comes to conclusion on the ground that the PWT has adduced evidence and she has clearly stated they're living separately with their husband and
Is this matter in the month of January?
please.
January, no representation on behalf of the. It's there.
125, list number 1, passover matter.
This
A.
adjourned.
Krishna Swamy,
After.
Please.
Bill for the appellant, my lordship.
Oh.
My lordship, this is a case of no deal, my lordship, in a tribunal, the para number 23, my lordship.
Let's see.
It was assessed. So that's the reason pain recovery order.
Liable to pay and directed to deposit the components in a period of 1 month from the date of award. Respondent number 2 is, according to you, pay and recovery is not applied.
Is a pain recovery order, my lordship. It's not a order for pain recovery.
That's
Insurance
what-
company is liable.
And on quantum, you are not on quantum.
No, my lordship.
Please come. Agreed with the award passed in MVC number 273 of 2022 dated 16 January 2024 by so and so. The claimant is before, the insurance company is before this court questioning the liability. The tribunal has fixed the liability on the insurance company. While fixing the liability, the court has observed that accident has taken place due to negligence on the part of the rider of the motorcycle. The court says breach of conditions are not proved.
In a charge sheet, my lordship, there is the one line, my lordship. Motorcycle ಚಾಲನೆ ಮಾಡಲು ಚಾಲನಾ ಅರ್ಹತಾ ಪತ್ರವನ್ನು ಹೊಂದಿರುವುದಿಲ್ಲವೆಂದು ತನಿಖೆ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. That means there is no DL for the rider of the vehicle.
That accident has taken place due to the negligence on the part of the rider of the motorcycle. It is submitted that the breach of any policy conditions are not proved. It is not disputed that the first respondent is the owner and the second respondent is the insurer. Hence, first respondent being the owner and the second respondent being the insurer of the offending motorcycle are jointly and severally liable to pay the compensation. When counsel appearing for the insurance company submits that, as per the charge sheet, exhibit P6, there is no driving license to the driver of the offending vehicle. When there is a clear violation of the terms and conditions of the policy, in the light of the law laid down in Forensics case, the principle of pay and recover applies, and the tribunal has not.
Exhibit P9, my lordship. Exhibit P9.
Yeah. And the tribunal has not considered this.
Charge sheet P6.
Next, when counsel appearing for the respondent claimant submits that the court has rightly considered and fixed the liability on the insurance company, and there are no grounds available. There are no reasons to interfere with the well-considered order passed by the tribunal. Next part, having heard so and so. The tribunal has held that there is no violation of, there is no breach of terms and conditions of the policy. But exhibit P6.
Yes, my lordship. P6, my lordship.
Exhibit P6 charge sheet shows that the driver of the offending vehicle is not having a valid driving license. Once he is not having a valid driving license, the principle of pay and recover will apply in the light of the law laid down. It's Forensics case. In that view of the matter, the appeal of the insurance company is allowed, and the compensation of an amount of rupees 4,01,180 shall be paid by the insurance company and shall recover the same from the owner of the vehicle. Where is the owner of the vehicle? Is it the,
Respondent number 2, my lord.
in that, while recording their submissions, though notice is served on the owner of the vehicle, no wakalat is filed. No, it's insurance companies, yes. Accordingly, appeal is partly allowed. Yes.
Much
List
obliged,
number
my lordship.
2, serial number 6. 2, serial number 6.
I appeal for the appellant in this case.
Ashok N14.
In this case, my lords, the
What ground?
my lords, negligence is questioned, my lords. The accident is between, my lords, the auto rickshaw which was taking a turn, my lords, and the motorcycle has come and hit.
So according to this contributory negligence on the
50-50,
part of
my
the-
lords, is held by the tribunal. But I am questioning that, my lords, the proportion should be, my lords, much higher than that, my lords. Kindly see.
And what you say? What
My
is
lord.
your appeal?
My lord,
It shouldn't be 50.
my appeal is enhancement of compensation.
No, about contributory negligence.
Contributory negligence, my lord, the claimant is inmate of auto rickshaw.
Hmm.
There is no contributory negligence on the part of the.
Claimant is inmate.
There are two
It's
vehicles,
like-
two
no, no,
insurers.
no.
Two insurers, no, it is not on the claimant, my lords.
We will read that paragraph.
Please.
Where is it?
Para 16.
And para 16, my lords, is the discussion about that, my lords, how the negligence, my lords, is the counsel for the respondent.
No, first of all, we'll understand issue number 1.
Please.
So that we'll understand how the accident has happened. Let's read from the counsel for the petitioner, paragraph 10.
Please.
Yes.
The counsel for the petitioner has argued that the petitioner sustained injuries in a road traffic accident occurred on 30/12/2019 due to rational negligent riding of the rider of the motorcycle bearing number so and so, and also the driver of the auto rickshaw bearing number, as the driver of the said auto without giving any signal turned the auto. The petitioner, in order to prove this aspect by way of documentary evidence, produced exhibit P1 to
The
P7.
opposite vehicle is a
Motorcycle.
Motorcycle.
That is insured with the. both
Insured
respondent.
with, my lords,
you insured auto.
I
Yes,
insured the auto, my lords. The petitioner, in order to prove this aspect by way of documentary evidence, produced exhibit P1 to P7. That is FIR, complaint, spot measure, seizure measure, IMV report, charge sheet, and the wound certificate. On perusal of exhibit P1 to P7, it clearly goes to show that the accident had taken place due to the rational negligent driving of the rider of the motorcycle bearing number so and so, and also driver of the auto rickshaw number so and so. Further, on perusal of exhibit P6, IMV report, it is mentioned that the motorcycle bearing number and auto rickshaw bearing number was tested, and it was found that the brake system was in order, and the opinion was formed that the accident was not due to any mechanical defect. Further, in view of exhibit P7, charge sheet, as the charge sheet is filed against the driver of auto rickshaw and rider of the motorcycle, it goes to show that the rider and driver of the vehicles had committed the accident. Therefore, the police have charge sheet after investigation. Thus, in view of the police records produced by the PW1, it clearly goes to show that the accident had taken place, as it is the allegation of the petitioner that the rider and the driver of
Respondent number 1, 2, 3 are?
No, total not respondent 1 to 4, my lord.
No,
Respondent
1 to
number
3 are
1
to-
is the, respondent number 3 is the owner of the motorcycle. 2 is the, my lord, Reliance General Insurance Company. That has questioned by the auto rickshaw insurer.
1?
One owner of the auto rickshaw.
So you did one, respondent number 1 to 3 did not come forward for filing objections and even not challenge the oral and documentary evidence produced by PW1. Under these circumstances, in the absence of challenging the oral and documentary evidence, no hurdle to accept the allegations made by them.
But we have adduced evidence, my lords. Our witness is, my lords, adduced.
No, he says you are respondent number 2.
I am respondent number 2, yes.
Yes.
RW2 officer of the company examined by.
Officer of the company is examined.
RW2.
No other evidence.
No other evidence
No other-
except.
What will our officer do?
May I request your lordship to kindly take, my lords, exhibit P6, my lord, the IMV report, my lords, which would indicate, my lords, how the injuries, damages to the vehicle, my lords. That's the only, my lords,
My
point.
lord, there is no question of negligence
Contributory
50-50,
negligence apart
as
from the-
rightly held by the MSCT, my lord, both have equally liable to pay the compensation
Kindly,
basing
Manoj,
on the
for a
witnesses and
moment,
charge
Manoj, you
sheet.
lost me.
You're saying contributory negligence.
Yes.
You have to adduce some evidence. By mere,
That too, my lord, 50% has already approached.
your officer, how will you?
It is
how will
only,
you-
Manoj, based on the documents, Manoj, and the, Manoj, the circumstances.
So what do you say about this particular observation in the order? The respondent 1 to 3 did not come, objections, you don't file your objection, and even not challenge the oral and documentary evidence produced by PWMR. Simply, you just examine your officer and keep quiet, and now you come before the court and say that my contributory negligence is not 50%, it should be less than
We,
that.
Manoj, we cannot, Manoj, question the, Manoj, police documents or
Not
the charge
questioning
sheet.
about it.
Yes,
You have to elicit something. You have to examine, you have to cross-examine the witnesses. Nothing you have done. That's what the
I am
observation
only,
of the
Manoj,
court.
basing on the, Manoj, IMV report, which says that, Manoj, kindly see, Manoj, for a moment. Manoj. May I-
What it
Manoj,
says?
But the damages to the auto rickshaw is, Manoj, one is left side body damage, left rear wheel mudguard damage, left side rear body damage. Manoj. This is how, Manoj, I was taking a turn, Manoj. He has come, Manoj, from the straight road and, Manoj, hit to the left rear side of the, Manoj. What are the, Manoj, damages to the two-wheeler is front wheel mudguard damage, front headlight and mask
Anyhow,
assembly.
for that it is no left and right.
Yes, Manoj. This is the, Manoj, front side. Manoj, what I am trying to, Manoj, point out is that, Manoj, I was already taking turn, Manoj. He has come from the straight without observing, Manoj, therefore, Manoj, some greater degree of
Yes,
negligence,
Mr.
Manoj.
Pradeep, the damages are to the left side. So that means you're trying to overtake the vehicle from the left side.
Not overtaking the vehicle, my lord. All of a sudden he took right, my lord. The motorcycle is going, my lord. They are saying that, my lord, there is a done collision.
He's behind or he's coming from which
No, my lord,
direction?
not behind. The conclusion may kindly be seen. Not behind.
Where do you get that?
Facts may kindly be seen. First para 2, my lord. The manner of the accident. The petitioner stated that on 13/12/2019 at about 6:50 p.m., the petitioner was traveling in an auto rickshaw bearing number KA16B 3537 as a passenger in order to reach Otapnalli village, Chalakere Taluk, when the petitioner was proceeding near Otapnalli cross NH 150A, Chalakere Taluk. Driver of the auto rickshaw, without giving any signals, turned the auto rickshaw. He is the inmate of the vehicle, my lord, who has deposited that the auto rickshaw all of a sudden, without giving caution, taken right.
What else you want? Yes, next. So come to the table.
His appeal is also there, Manoj, seeking enhancement.
That's what I'm looking at his, where is the table?
Table, my lord.
Manoj, ink page 23, Manoj, at para 15, Manoj, ink page of my appeal memo.
What are the injuries?
Injuries, my lord, fracture of both bones of right and left leg, my lord, comminuted fracture. Both legs fracture, my lord.
So 50,000.
Please.
Next, medical expenses.
Medical expenses, my lord, as per.
It is only, Manoj, 350 rupees, Manoj, as per the actual bills.
350.
50, yes.
Then loss, how many days he was in hospital?
25 days. 25 days.
25 days.
Incidental expenses, how much was that awarded?
The tribunal, Manoj, has awarded 20,000 rupees, Manoj.
So
Food and nourishment,
he was
10,000.
there in 20 or 25?
25 days.
So we'll grant 25. Then loss of income during laid up period.
Laid up period, my lord, granted only 14,000.
1 month is granted, Manoj.
Which year is this?
My lord,
2019.
19.
14,000.
30th 12, 2019.
15,000 into 4. It comes to 56,000. Any disability?
Disability, my lord,
Manoj, is
suffered,
awarded, Manoj. 16.93% is awarded.
No, what is the evidence of the doctor?
Evidence of the doctor, my lord, is assessed the disability to the lower limb 50.80%.
And to the whole body?
Whole body, my lord, trial court considered, my lord, 16.93%.
That is 1/3 is considered, my lord.
Both leg, both bones fracture, my lord.
Doctor has
Comminuted
deposed, my
How
lord.
much is considered?
Only 16.19.
Can be
16.93,
17. Can be considered as 17 because it comes to 16.93. So we will take it 17. So loss of
Income 14,000.
age,
Age, my lord, 16 multiplier has been adopted.
35
31 to
years.
35,
14,000 into 12 into multiplier is
16.
16.
16 into 17 by 100.
Pain and suffering, my lord, grant.
It's already granted now.
4,56,960.
Into 16. 4 lakh
56,960.
960. Yes. So amenities. How much is
10,000 is awarded.
10,000 is awarded.
We'll grant 30,000.
Please.
Yes, all the heads are covered.
My lord, pain and suffering, my lord, is
3,000.
sustained, my lord, both leg, both bones fractures. Comminuted
Yeah,
fracture.
tibia and fibula, tibia and fibula.
Both legs fracture, my lord.
70. It comes to 6,48,310 against.
5,09,428.
Yes, please come. Agreed with the award passed in MSc number 581 of 2020, date 7th December 2023 by so and so. Both the insurance company as well as the claimants are before this court. Insurance company's appeal is 1050 of 2024 and the claimant's appeal is MFA number 108 of 2024.
4, my lord. 24.
The claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by the claimant. It's the case of the claimant that on 30/12/2019 at about 6:50 p.m. the claimant was traveling in an auto rickshaw as a passenger in order to reach the village. At that time, the driver of the auto rickshaw, without giving any signals and crossing, turned the auto rickshaw. At that time, the motorcycle coming from Sanikere side in a rash and negligent manner with high speed dashed to the middle of the auto rickshaw. As a result, the accident had taken place and petitioner sustained injuries. The tribunal had fixed the contributory negligence both on the rider of the vehicle as a two-wheeler as well as the driver of the auto. The auto is insured with
Upland.
the Reliance General Insurance Company and the two-wheeler is insured with Liberty General Insurance Company. The tribunal has awarded the compensation as per the table given below. At paragraph number 15, the table, please extract the table. The insurance company, that is the fourth respondent herein, which has insured the two-wheeler, has not preferred any appeal. Only the company which has insured the auto is before this court. According to it is argued by the land counsel appearing for the appellant insurance company that as per the IMV report, the damage to the auto is on the left side, which clearly shows that the negligence is on the part of the rider of the two-wheeler. This fact aspect was not considered. Next part. Land counsel appearing for the insurance company, that is the which has insured the two-wheeler, submits that It is a case of the inmate himself, that is the claimant, that suddenly he has taken a right turn which led to the accident. And they have not adduced any evidence, any other evidence, except examining the law officer, the manager of the insurance company. It is submitted that when there is no contra evidence is adduced, the appellant insurance company cannot question the contributory negligence fixed by the court. Next part. When counsel appearing for the claimant submits that there is negligence on the part of the auto and the co-auto, as well on the part of the rider of the vehicle. Court had rightly fixed the contributory negligence at 50% on both of them, and there are no grounds to interfere. Then coming to the compensation, he submits that when the claimant had sustained 2 fractures to both the legs under the head of pain and suffering, the amount that is awarded by the court is not reasonable. Coming to loss of income due to disability, no much difference.
Please. Little difference. Some difference, my lord,
Support
1,000
no.
and add.
It is 4,55,000.
56,
It has become 4,66,000,
Please.
only 1 lakh difference. Because of that
Point
rounding off to
0.%.
it is submitted that when the disability is 16.9, the court ought to have taken 17% as a disability. It is further submitted that under the incidental expenses, loss of income during the later period and amenities, the amount that is awarded by the tribunal is not just and reasonable. And the same rates to be enhanced. Next part. Having heard the counsels on either side, there is a material on record. First, coming to the aspect of liability. The claimant, who is the eyewitness to the incident, has stated that there is negligence at the driver of the auto rickshaw was negligent. And if the driver of the rider of the two-wheeler is vigilant, the accident could have been avoided, considering that the court had apportioned the contributory negligence at 50% on both the rider and the driver of the auto. Except examining their officer and relying on the IMV report, no other evidence is adduced by the appellant insurance company. In that view of the matter, this court do not want to go into the aspect of the apportioned contributory negligence by the tribunal, and it holds good. Next part, coming to the compensation, considering the 2 injuries that are sustained by the claimant under the head of pain and suffering, this court is granting 70,000 medical expenses as it is. Towards incidental expenses, as he was in hospital for 25 days, 25,000. Loss of income during the later period, 14,000 into 4, 56,000. Coming to the loss of future income, this court is inclined to take the disability at 17%. 14,000 into 12 into 16 into 17 by 100 is 4,56,960. For the disability of 17% towards amenities, 30,000. In the light of the law laid down in Meghalaya
Lord,
versus so and so.
Future medical expenses, my lord, nothing has been
Was there
granted.
any evidence?
There is no evidence.
Then whether there is any requirement?
Not the implants is removal of
But where
implants.
did the doctor say that the implants have to be removed?
In his evidence, my lord, not stated.
The legal expenses, 10,000, in the light of the law laid down in Meghalaya. Altogether, the claimant is entitled for an amount of 6,48,310. Accordingly, appeal is partly allowed, enhancing the compensation from 5,09,048 to 6,48,310. The enhanced amount shall carry 6% interest. Any delay?
No.
Amount in deposit may be transmitted.
Yes, amount in deposit shall be forthwith transferred. Yes, next. No, in the earlier matter also, which is that A.N. Krishnaswamy, which is the number? In that also, amount in deposit shall be forthwith transferred. Insurance companies are in the earlier list. Yes.
Till number 7.
So the appeal filed by the insurance company, MFA number 1050/2024 is dismissed. MFA number 108 of 2024 is partly allowed, enhancing the compensation from so and so to so. Yes, next.
7. Gudev Prasad KT, appellant, MS Bengali.
Case of death knell. The tribunal has held that there is a contributory negligence of 20% by the deceased, 80% on the BMTC.
And about the quantum?
Quantum, the court has taken, he was a contract, he was doing contracting work, and 14,250 has been taken. The accident is during 2021, 15,000.
So now we are on the contributory negligence first. And what is his age?
He was riding the motorcycle and bus.
Age.
Age is 49 years. 13.
So, 10% future, 25% future process. Was granted?
Granted.
So income is only, then what is, how many are the dependents?
Four persons, 1/3 has rightly deducted.
So, come to that aspect of contributory negligence.
Para Tolomel.
The charge sheet may not filed against.
Records are there, your lordship.
Both
The records are there, your lordship may kindly see exhibit P13
So
sketch.
what do you say for the charge sheet?
Charge sheet is against the bus driver.
No, against both.
Against the claimant is saying.
Against the deceased mode.
But that's what, against the deceased also. Then there is a question of now going into other aspects. 20% is already on the lower side when charge sheet is filed against him. Look at it, pass over. If
No,
the charge sheet.
No, it has been observed not by the tribunal.
Exhibit?
No, your Manoj Kumar, the driver of BMTC bus.
No. Exhibit?
Exhibit P.
P12 mode.
P12.
Point out from exhibit that
Oh, P12 mode.
P12.
That portion.
Column
is
number.
charge sheet.
No,
Column
it is
number
there.
12.
Accused number 2.
Column number 12.
Yes.
Venkatesh Rider.
Shall we calculate the enhanced? Yes. So, court had taken how much you said?
14,250.
14,250.
So we'll calculate on this.
15,000 has to be taken. And conventional.
25% future prospects. One third has to be deducted.
One third mode. One third deduction. Comes on 19,50,000.
Multiplier?
13.
13.
Coming to 19 lakh
50,000.
50,000. 1,32,000 is the 4 or 3?
For
4 into
conventional
40.
rates.
1,76,000. It's coming to 21,72,000. How much was awarded by the tribunal?
19 lakhs 22,500, deducting 20%.
Lakhs?
19 lakhs 22,500.
And after deducting mode, 15,38,000 has been awarded.
15 lakhs?
38,000.
Page number? Please come to the. Mm. 19 lakh 22,500.
Yes.
After that, it will be 15 lakh 38,000.
Yes.
So in this case, 80% into 80 divided by 100 is 17 lakhs. Now you have to pay 17 lakhs 37,600. The agreed with award pass on MSC number 2385 of 2021 dated 1st February 2023. The claimant is before this court seeking enhancement of the compensation. The court has granted the compensation as per the, is before this court questioning seeking enhancement of the compensation and also the questioning the contributory negligence that is fixed at the deceased at 20%. Next, the tribunal has granted the compensation as per the table given below at paragraph number 20. Then counsel appearing for the claimant submits that when this accident had taken place in the year 2021, the court had taken the income at 14,250 instead of 15,000. Even at the conventional heads also, the amount that is awarded by the tribunal is not just unreasonable. Next, it is submitted that the court has fixed upon the contributory negligence at 20% on the deceased without any basis, and there is no contributory negligence on his part. Next part, when counsel appearing for the respondent submits that the court had rightly fixed the contributory negligence at 20% as the deceased was arrayed as accused number 2 in the charge sheet. It is submitted that there are no grounds to enhance the compensation, and the appeal has to be dismissed. Next, having heard so and so, there is a material on record. The first contention with regard to the liability, the court had rightly fixed the liability at 20% on the deceased and 80% on the offending victim. There is no dispute about the fact that he has been arraigned as an accused in the arraigned as an accused in the charge sheet that is filed with in the charge sheet. In those circumstances, this court do not want to go into that aspect in the petition as far as that ground is this court the same. The appellant, the same cannot be considered. Next, coming to the quantum, at this accident taken place in the year 2021, this court is taking the income at 15,000. 25% future prospects would come to 3,750. Then it is 18,750. As there are 4 claimants, 1/3 is deducted, 6,250. Then his contribution to the family is 12,500 into 12 into 30. Loss of dependency comes to 19,50,000. 44 into 4, 1,76,000 towards loss of consortium. The funeral expenses 36,000, legal expenses 10,000. Altogether, the compensation comes to 21,72,000. As 20% is the contributory negligence on the part of the claimant, the insurance company is liable to pay 17,37,600. Hence, the compensation is enhanced from 15,38,000 to 17,37,600. The enhanced amount shall carry 6% interest. Any delay?
Delay.
280 days delay unknown on condition. So it shall come in that they are not entitled for the interest. Yes, after lunch. No, after lunch I will take up the 230 matter, then we'll continue this list.
Leave of the court may make one. Leave of the court may make one submission. Serial number 19, Madam, that is wrongly connected another case, Madam. The case is 79.
The appellant in that matter.
It has to be dealing. Tell the court officer.
My lord, adjourned, my lord.
Huh?
It may be
So, no, they will dealing it.
no, another matter is there, my lord. It had to be posted along with that one.
Then give both.
Yes.
My lord's one submission, my lord.
No submissions now. Yes. Any signatures?
Serial number 33. First list. So 1
Maybe ಒಂದಿನದ್ದು 2 ದಿನದ್ದು ಹೇಳಿ.
ಹೌದಾ? ಜಾಸ್ತಿ ಅಲ್ಲ 230? ಅಷ್ಟೇನಾ? ಒಂದು 1 ಅವರ್ ಆಗುತ್ತಲ್ಲ ಮೇಡಮ್, 1 ಅವರ್ ಬರ್ರಿ ರೆಡಿ. ಹೇಳ್ರಿ ಹೇಳ್ಸ್ಕೊಡಿ. ಹೇಳಿ. ಬೆಳಗ್ಗೆ ಗೊತ್ತಾಯ್ತು ನೀವು ಕೇಳ್ಕೊಡ್ತಾರೆ. ಮೆಡಿಕಲ್ ರಿಇಂಬರ್ಸ್ಮೆಂಟ್ ಅದು ಅಪ್ಲಿಕೇಶನ್ ಅವ್ರದ್ದು. ಅದೆಲ್ಲೂ ಇಲ್ಲ. 4A
ಹೇಳಿದ್ರು 10 ಸಲ ಓದಿಸಿದ್ರು ಇವತ್ತು ಬೇರೆ ಪ್ರೊವಿಷನ್ ಓದಿಸಿದ್ರು. ಇಲ್ಲಿ ನೀವು ಕೂಡ ನಾವು ಇಲ್ಲಿ ಕಟ್ಬೇಕು ಅಂತಿದ್ದೇವೆ. ಅದು ಬಿಡ ಲೆವೆಲ್ ನೋಡೋದು ದೊಡ್ಡ ದೊಡ್ಡ ಸರಿ ಸಾಹೇಬ್ರು ಕೇಳಿದ್ರು.
ನಮ್ಮನ್ನು ಕೇಳೋರು ಕೇಳಕ್ಕೆ ಬಿಡಲ್ಲ.
ಸಾಹೇಬ್ರು ಕೇಳಿದ್ರು.
ಅದು 35 ರೀಚ್ ಆಗುತ್ತೆ.
ನೀವು ಇಂಡಿಪೆಂಡೆಂಟ್ ಮ್ಯಾಟರ್ ಬರ್ಸ್ಕೊಡೋದು ಇನ್ನು ಸಿಟಿಗೆ ಹಾಕ್ಬೇಡ ಅಂತ ಮೊದಲನೇ ಹೇಳಿದ್ದೀನಿ ಸರ್. ಅಲ್ಲಿಗೆ ನೋಡಿ
ಸ್ಟೇ ಮಾಡಿ ರೊಕ್ಕ ಬರ್ತಿಲ್ಲ ಸ್ಟೇ ಮಾಡಿ ರೊಕ್ಕ ನಾವು ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿ ಕಳಿಸಿದ್ದೇವೆ ಮಾಡಕ್ ಬೇಡ 50% ಮಾಡಿ ವುಡನ್ ಸೇಲ್ ಮಾಡಿದ್ದೇವೆ ಎಲ್ಲಿ ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ದೇವೆ ನಾನು ಏನು ಸೈನ್ ಮಾಡ್ತೀನಿ ಅವಾರ್ಡ್ ಏನು ಮಾಡ್ತಾರಲ್ಲ ಓ ಅದು ಇದು main recovery. ಇದು ಇದನ್ನೇ ಕೊಂಡು ಎಷ್ಟು ಸಣ್ಣ
ಲೈಟ್ ಇಲ್ಲ
ಲೈಟ್ ಐತೆ
ಲಾಕ್ ಮಾಡ್ಬೇಕು ಏನು ಮಾಡ್ತೀರಿ ಇದು ಕಂಪನಿ ಸೇಲ್ ಮಾಡಿ ಕಳಿಸಿ ತಗೊಂಡು ಫೈಲ್ ಮಾಡ್ಬೇಕು ಐತಲ್ಲ division bench 75 days complaint.
ಅವರು ಇಂಟಿಮೇಷನ್ ಕಳ್ಸಕ್ಕಾಗುತ್ತೆ
MLC ಇಲ್ಲ MLC ಇಲ್ಲ
ನೋಡ್ರಿ ಸತೀಶ್
ನೋಡ್ಕೊಳಪ್ಪ ಅದ್ರೊಳಗಡೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಲ್ಲ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಆ ಸೀರಿಯಲ್ ನಂಬರ್ ಫೈಲ್
ಮೂವತ್ತೆರಡು ಸಾವಿರ ಮೇಡಮ್ ಅವರು ಸರ್ ಮತ್ತೆ ಇನ್ನು
ಒಂದೇ ಸರಿ ಆಗ್ತದೆ ಕೊಡಂಗಿಲ್ಲ
ಅಲ್ಲೇ ಒಂದು ಕೇಸಲ್ಲಿ ಕೊಟ್ಟು ಕಟ್ಟಲಿಲ್ಲ
ವೆಹಿಕಲ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಮೇಡಮ್ ಸಬ್ಜೆಕ್ಟ್ ಫಸ್ಟ್ 50% ನಾನು ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ರೆಸ್ಪಾನ್ಸ್ ಆರ್ ಲಿಬರ್ಟಿ ಟು ವಿತ್ಡ್ರಾ ಅನ್ಕೊಂಡಿದ್ದೀನಿ ನನಗೆ ಮೇಡಮ್ ಕೇಳಿದೆ ಅವ್ನು ಕೊಟ್ಟಿರ್ತಾರೆ ಅದ್ರಲ್ಲಿ ಬಂದಿಲ್ಲ ಬರೀ 50% ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ ಇಲ್ಲಂದ್ರೆ ಅವ್ರು ಹೇಳಿ ಮೇಡಮ್ ಹೇಳಿ ಬಂದ ತಕ್ಷಣ ಹೇಳಿದ್ವಿ ಅದು ಕೇಳಿ ಮಾಡಿ
ಇದ್ರಾಗಿಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಆಗಿಲ್ಲ ಇಲ್ಲಿ ಮಾಡಕ್ಕಪ್ಪ ಇಲ್ಲಲ್ಲ
ಅದಲ್ಲ ಕಾಫಿನ ಸಿಕ್ಕಿಲ್ಲ ನಾನು ವೆಬ್ಸೈಟ್ ಕಂಪ್ನಿ ಇದರಲ್ಲಿ ಲಿಬರ್ಟಿ ಟು ವಿತ್ಡ್ರಾ ಮೇಡಮ್
ಬೇರೆ ಯಾವ್ದು ಸರ್
With the kind permission of your lordship, with the kind permission, on 25/10, I had made my submissions with regard to the stay in company appeal. Your lordship was kind enough to pass an order saying that the involvement of the vehicle is in question. Anta. Even then, and this honorable court, true to my conscience, only 50% deposit in 4 weeks it has come. I've just cross-checked with the cause list also. But in the website, your lordship, the respondents are at liberty to withdraw. It's what appearing. So, kind.
My lords, serial number 88, my lords, I am for respondent. I was held up in other court all, my lords.
So what happened?
My lords, there were two IA. One to condole the delay which is filed by the appellant. other I have filed to withdraw the amount where
That I'm not granting. I'm hearing the matters. You give a memo someday, we will take it up for hearing. Yes, please.
230 matters. List number 3 for orders matter serial number 1 BC Shivanna Gowda.
Matter may be kindly pass over.
Yes.
Serial number 2. ಅದು ಅಷ್ಟೇ ಸರ್ ಔಟ್.
Pass over.
Serial number 3
Three in this case, not.
Ramesh Penny.
My, when I verified in the office, 38,000 to be deposited until ಹೇಳಿದ್ರು. I have deposited 40,000. Now again, office objection may not 3,390, I will deposit that also within 4 weeks. Kindly stay the matter.
Lord, we have filed a QA
You,
petition.
for depositing 399 rupees, you want 4 weeks time.
Allah, 4 weeks, check to be down by the Madras film. That is the problem. Now,
Wherever
office-
it is, please do it. Madras is not somewhere in.
No, I have to send to my regional office, divisional office, divisional send to the regional office send to the head office. That is the reason. I will deposit without fail within, if not deposit within 4 minutes, kindly vacate the, and Bekare held.
What is this? Why this kind of?
No, when I verified in the office place, they told me 38,000. I have deposited 40,000. I expected they may calculate up to.
Non-compliance of office objections.
I will deposit that 330.
Non-compliance of office
I
objections.
can understand. I have deposited the 15 lakh to 12,000 and also 40,000. I will deposit that amount. I will deposit within 4 weeks. Kindly stay the matter. I may be going to serve the copy and the.
My lord, we have not received the copy.
3 sets. 4 sets. For claimants, please. Without fail, I will satisfy that, deposit that amount, please.
The appellant insurance company shall deposit an amount of rupees 40,399 as calculated by the office. Once the amount is deposited, list this matter. Why did you give the memo?
Please, madam.
Why did you give the memo when the court said only the matter has to be listed once the.
Well,
amount is-
I heard that my lord lordship is there, directed me that 38,000 balance is there, not therefore I deposit the 40,000. 2,000 extra, but now on seeing the office objection, another 390 rupees deposit.
I said 40,399. I think you can read the order.
I'll kindly stay the matter, please,
I will
within.
not do it. This is matter after the amount is deposited. And no memo, even if a memo is given, don't post this matter unless the interim order is complied with. Yes.
Serial number 4 B Pradeep.
Yes, my lord, liability is under challenge, my lord. It's limitation, my lordship.
What about other two matters of Shivanagowda?
My lordship,
Shivanagowda matter.
same matters, my lord. 1 and 2, serial number 1 and 2 also same.
Land council appearing for the appellant submits that though the amount in dispute is less than 1 lakh, still the appeal is maintainable as insurance company is on the question of liability. And this court has passed several orders in several writ petitions. Same order in 1 and 2 also. Accordingly, the office objections are overruled. Yes.
Serial number 5 Rajat.
Lord, initially, interim order was granted, my lord, to pay a sum of rupees 8 lakhs. Lord, due to, there was some medical emergency in the family members, my lords. But recently, my lords, in the first week of November, they have paid 10 lakhs, my lords.
What
Now
was
there
the
are,
order?
the interim order was for payment of rupees 8 lakhs, my lords, within 4 weeks, 3 weeks.
22/5/2025, after 5 months.
Yes, my lords. But there was a medical emergency, my lord, to that effect.
Who appears with the bank?
None of
No
the.
notice was ordered.
Notice was ordered.
Furnishing of PF.
My lord, as per
Which
the-
bank is this?
My lord, it's a private bank, my lord, Edelweiss's Asset Reconstruction Company. As per the postal acknowledgement, my lords, it has been served upon them.
Where do you get it? Huh? Is it served?
No.
He says
It
served.
is served, my lord, as per the. High Court executed.
Website.
A postal information ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. They had paid 10 lakhs in the first week of November.
Office shall place before this court regard to the service of notice and the status of the notice that is sent to the respondent.
My lords, interim order, my lord, because we have paid rupees
Order
10 lakh
granted is
rupees, my lords.
Extended as it is submitted that an amount of rupees 10 lakhs is already deposited by the petitioner
By way of DD, my lords.
by way of where
The bank only, they have deposited 10 lakh rupees.
you have deposited. You have deposited before the bank, that I will record.
Yes, ma'am.
That they
I'm
have
filing with
deposited
memo.
10 lakh rupees by way of DD. It is submitted that because of the medical emergency, the same could not be deposited within the time as per the interim order passed dated so and so. Considering the fact that 10 lakhs is already deposited, they should be, the stay granted on so and so is extended till the next date of hearing. Yes.
Much obliged.
In appearance for petitioner in this matter, we have filed a withdrawal memo for this.
When is that memo?
So withdrawal application, my lordship, that for necessary liberty to file a necessary application
What is
before
this
this.
petition? What is the necessary application? Writ petition is filed for what? Liberty will not, we don't grant liberty just like that without knowing why you have come before the court.
Approximate.
Entire proceedings in MC number 3961. The present writ petition is filed, seeking the following prayer. Now the memo is filed stating that to withdraw this writ petition with a liberty file to file necessary application before the family court. This court cannot quash the MC proceedings and not for any reasons if it is for the petitioner that the MC is not maintainable. He can approach the trial, he can approach the family court in that view of the matter. The writ petition, the memo is taken on record. Writ petition is withdrawn and dismissed as withdrawn, giving liberty to the petitioner to avail the remedy before the family court.
Much obliged.
Hearing on interrupted application 7.
I appear for the appellant.
Mama Shetty.
I appear for the appellant. There is a delay of 91 days and I have sought for stay also.
On
This
what
is
ground you have before the court?
The deceased was not holding the driving license when he met
When
with
was
an
the
accident. Accident took place in the year 2021,
So before amendment,
23/5/2021.
so what was the amount granted?
He was a pensioner more than 65 years. Amount granted was 14 lakhs and where under 8 lakh rupees medical expenses were granted without original bills. That is my grievance before this honorable court, that without considering the objection of the insurance company.
The driver was not having a valid driving record. And further, the court has granted 8 lakhs as medical expenses without even finding the original medical bills. Next, considering the same, they shall stay on the condition that the petitioner shall deposit, the appellant company shall deposit 8 lakhs and on deposit of this 8 lakhs within 4 weeks, and on such deposit the respondents are at liberty to withdraw notice.
Cell number 8. 8.
Notice.
Cell number 9.
Notice.
Cell number 10.
Notice.
11.
Notice.
Cell number.
Respond number 1, kindly notice may be dispensed.
Huh?
Respond number 1, kindly notice may be dispensed.
Memo is facing a dispensation of notice to respondent number 1. 2 is
2, my lord, Tata AIG Insurance Company.
Mr. Sis Mulkand is directed to take notice on behalf of the insurance company. There is a delay of 272 days, condoned on condition. Admit final guarantees here.
12. Jagdish Shetty.
For dispensation of notice to R1 and R2 minutes.
This R1 dispense.
R2 also.
R2 dispense with
R3 is the ICICI Lombard General Insurance Company.
Mr. Pradeep is directed to take notice on behalf of the insurance company. I number 1 to condone the delay of 149 days, condone on condition 13.
But kindly refer to Lok Adalat.
12,
12, refer to
12 refer to the Lok Adalat. 13,
13,
Respondent number, kindly notice may be dispensed with, madam.
two
Respondent
respondent
number one. Respondent number one.
Respondent number 1, dispensed with. And 2 is
Two, Magma HDI General Insurance Company, madam.
Magma, who appears?
B. Pradeep, BCC
Pradeep
Vanagoda.
appears. Pradeep is directed to take notice on behalf of the insurance company. 99 days, 99 days delay condoned on condition, admit final hearing to.
14, B. Pradeep.
Following
Notice.
the liability matters, self-acceptable charge sheet filed against the deceased himself. Compensation awarded 5 lakh.
It is submitted that the insurance company is before this court, questioning the liability fastened on the insurance company when the charge sheet itself is filed against the
Deceased.
Considering the same, they shall be stay of all further proceedings. On depositing of 50% of the amount within 4 weeks. Yes, notice to the respondent.
Cell number 15, Narendra Gowda.
Taken up on Monday, because talks were going on between the bank and one-time settlement for.
It is submitted that there is a scope of settlement and they're negotiating for the one-time settlement. List this matter next week.
Monday,
Yes, list this matter on 17.
please.
Cell number 16,
We are for the petitioner, madam.
Jagdish JR.
Sale, my lord, I sailed before this honorable court. My lord, I supposed to get a bidder, my lord, 11/11/2025.
What is that?
There's no bidder. My lord, 11/11/2025. Yesterday, my lord, was the last date, my
So
lord. received
auction
it.
could not be conducted. So what is this?
Taking possession is also questioned, madam.
Declare the sale notice as per annexure as
That
valid
is
law.
prayer,
Here
A
it
will
go.
not survive, madam.
Bank to open
Yes,
poultry
madam.
breeding farm by holding that.
Possession has been taken, it's a poultry farm, madam, that they have
Why
taken.
is it bad?
That they received the money just prior to that. They, from January up to June, they were taking. The possession notice was issued prior to that, madam. They revived it actually.
Outstanding now.
My lord, the sale notice which I indicated 46,53,000 rupees.
How much?
4 crore 65 lakh.
No, that is the amount, sale action amount.
That's
What-
outstanding.
No, that is not the outstanding is.
My lord, I'm so sorry. 2 crore 18 lakh 29,702.
2 crore?
2 crore 18 lakh 29,702.
After that, we have paid 12 lakhs.
12
Ah.
lakhs, 12 lakhs in 2 crore 19.
No. What is, Milan, actually the payment defaulted is only 23 lakhs as of now. What they have calculated is from considering it as a NPA
Was the account declared as NPA?
in 24, Milan. Thereafter, they continued to receive money from me, Milan. It was declared NPA, in fact, on
To say, Mr.
28/6/24. Thereafter, yes.
Yesterday, my lord, they mentioned that, my lord, today sale is there, my lord. That is the reason, my lord.
You file your objection.
I'll file now.
Yes.
Otherwise, also, my lord, this petition is not maintainable for the reason is, my lord, kindly come to the prayer sort. First prayer, my lord, sale, which, my lord, declare the sale notice dated 24/9/2025, the sale not taken place, my lord, for the relief.
That goes.
No, yesterday you were telling about something like declaring the account to NPA. After that, if they pay the entire amount from the day to this,
Once back, this
whether there is a scope for regularizing the account.
Yes.
of-
That, certainly I'll verify, my lord.
Yes.
Matter reaching
The
this.
petitioner shall approach the bank when he is ready to pay whatever from the date of.
No need to, my lord, direction. The reason is this. I may not able to regularize. Let me find out what is the, my lord.
I'm not saying to regularize. I'm only asking him to, and you please tell him what it is. That's it. It is submitted that the account is declared as NPA on what date?
28/6/24.
28/6/2024. And after that, the respondent bank has received an amount of,
More than 50 lakhs they have received, Milan.
according to the petitioner,
15.
an amount of rupees 50 lakhs is received by the bank. What is the monthly EMI?
3 lakhs.
They have received more than 50 lakhs. The petitioner shall approach the bank, and if there is any scope for, what do you call it, restructuring?
Restructuring.
If there is any scope for restructuring the loan, if the bank rules, the RBI guidelines permit for the same, the bank shall come out with the restructuring proposal.
Restructure stroke regularization. Regularization or restructure.
Regularization of the account or restructuring by the next date of hearing. List this matter on 25th of September. Till such time, no coercive steps.
25th of November, September.
November.
Hello, my lord, course is step, my lord, as of now, there is no, my lord, the reason is this.
Anyhow, it is, it's like you're not taking when they are ready, let's see. Yes.
Bill number 17, Bharti M for petitioner. My lord.
Yes.
The petition challenging 125, my lord. There is a maintenance given to wife.
How much?
5,000 is the maintenance, but already DV is also filed and there also I'm paying 5,000, my lord. I produced.
What is your income?
My lord, I'm a coolie. I'm working in a timber. Like it depends on the work which I'm doing. Minimum 10 to 15,000 per month I will receive, my lord.
Then what is the final?
I'm a fabricator workers, my lord.
Let's see the funding of the family court. Why
Yes.
it has granted that?
Yes, ma'am. My lord, the facts are the family court's order, my lord. It's in page number 14, annexure A, my lord, which has given maintenance of 5,000 every month to be paid, my lord. According to the facts of
Counsel appearing to the petition submits that the court has granted maintenance of an amount of rupees 5,000 to the wife. Further, it is submitted that in the DV proceedings, court has already granted 5,000 and the petitioner is paying. He is working as a.
fabricator, my lord. Daily based work, like whenever there is a work, they'll call him.
And his income per month is 15,000. And now, by virtue of this order, the petitioner has to pay 5,000, 10,000 as maintenance. Consider that this court has perused the order passed by the tribunal, passed by the family court. There is no mention about what is the income of the husband. In these circumstances, there shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 2,000. 2,000 by 5th of every succeeding month, and the arrears also at that within 8 weeks.
My lord.
Notice to the respondent.
Bill number
The execution may be stayed, my lord. They have already. made
That's what I said. Stay.
Please, my lord.
18,
Please,
Kaleshappa.
You are challenging the position notice, please, my lord.
Huh?
Position notice, you are challenged, please, my lord.
Which bank it is?
Please. This amount, balance amount is, they are claiming the 4,96,000, please, my lord.
Whatever it is, without the bank's appearance, we will not, it's a Bangalore bank. The representation is permitted to take out hand summons on the respondent bank. Once the memo is filed, list this matter.
Bill number 19,
Date may begin, please, my lord.
Huh?
Date may begin.
Once immediately, if you file the memo, it will come. If it doesn't, you file a memo, we will list the matter.
Please.
Bill number
It's
19, Prasad Egde.
Position notice, my lord, 13/4, my lord. Only I requested for restructure annexure B, my lord. Instead of 388 per month, my lord, I said, my lord, I will pay 5 lakh. They have received the 5 lakh, my lord, but they have not given any consent order, my lord. Entire Lordship can see the payment schedule. Even single month I have not missed, my lord. Annexure D, my lord, in page
Same.
30.
Hand summons on the respondent bank. Same order like earlier. Yes,
20,
next.
Bill number 20.
I appear for the petitioner.
Prasad
Hence,
Egde.
the petitioner had filed the several application under the same provision of law, my lords. So, my lords, I would like to read the annexure H, page.
It's his
Lord's
writ
This is the
petition.
doctor one, please.
It's his writ petition. Let him argue. Then you
Petition
can.
already submitted the argument.
I don't remember what has been
Yes.
submitted on the last occasion. Yes.
Please, my lords, may kindly peruse that the petitioner is the husband and there was already an application
What is
filed.
that? First, WP 32768.
My lords, this is the subsequent petition filed. If I may request my lords to kindly peruse 20.1, which is the prior writ petition, my lords, 31691.
Arising out of what?
Arising out of an order passed by the trial court under order 16 rule 1 and 2, my lords. Initially, the petitioner had filed for divorce in the Mandya court, my lords, which was numbered as 80/2017.
It's about the expert evidence.
Yes, my lords. The
Expert
doctor.
expert evidence is which one? 31691 or 32768?
Unfortunately, it is both, my lords. What has happened is, under order 16 rule 1 and 2, that application came to be rejected by the trial court, which the petitioner had filed one more application seeking to recall the order, my lords. Even that application came to be rejected, hence both the petitions, my lord, challenging both the orders.
Lordship, kindly see the page
No,
47
before
English.
going into the technicalities.
Yes, my lords.
The issue
Because
is
firstly,
already an expert evidence, he filed an application that was ordered.
yes,
The
my
expert was not examined. The matter later was transferred from there to Bangalore. What is the prejudice to the wife if
My
this
lords,
application is
the
allowed?
trial court has given several opportunities to examine the doctor witness, my lord.
Not before this court.
Not before this court, my lords, the trial court. But has misusing that order, has filed suppressed that order, and again he filed the another one application under the same provision, my lords.
Which,
Then in that application,
which year is this MC?
2019, one application they filed, my.
No,
my lords.
MCs of which year?
17, my lords.
17.
Now you don't worry about it. We'll ask the court to allow this application as well dispose of the matter by January.
Yes, my lords.
Please.
Without fail, lordship may pass an order, give direction to them.
Yes.
Otherwise, one submission, my lords, we are ready to compromise the case, my lords. So, but he is not ready to settle the matter, because we are ready to settle the matter, and so if he is ready to give the permanent.
Unfortunately, my lords, before my learned friend coming on record, before my learned friend coming on record, my learned friend has come recently on record, my lords. Prior to my learned friend coming on record, there were many advocates who had filed wakalat, my lords, and every single occasion, my lords, the petitioner had tried to settle the matter, and the respondent has been hell-bent in not settling the matter, my
Then
lords.
let both of you come to the, will,
Mediation.
both the parties.
Yes.
Shall appear before the court in the chambers at 5 p.m.
Please, my lords.
On 26th November.
Please, my lords. Much obliged.
Serial number 21,
Yes.
Gauhar Unisa,
How much is granted?
25,000, my lord.
25,000 to the
10,000 for the wife and 5,000 each for 3 children, my lord.
10,000 to the wife and 5,000 each for 2 children.
Please, my lords. Here what has happened, my lord, by
What's
suppress.
your income?
I'm housewife. I have to take care of my children. Wife petition. This is wife's petition.
Then for enhancement, notice to the respondent.
My lord, may I make one submission, my lord. Respondent has already filed writ petition number.
List along with so and so.
My lord, I just would like to bring one, this thing, my lord, kind attention to this court. What has happened, my lord, in that
What
order as
happens
per
is,
Annexure K.
when you're seeking enhancement, let other side also be there.
Please, my
Because we
lords.
can't be, it's a,
My lord,
even 1 minute also we shouldn't waste on this.
Please, my lord.
It's of no use
It's
now.
my request, my lord, your lordships may kindly
No, no,
see
list
paragraph
along
1.
with the-
Here
list
what
along
has
with the-
happened, my lord,
for
here
next week.
husband has made one application, my lord. He has just made one submission and obtained order
Whatever
saying
it
that
is you-
he has deposited 250,000 towards the school fee to the school. He has not furnished. Even today, children have been sent to the, sent home because she has not made any payment.
This is matter on next Wednesday. Yes.
1911.
Along with so and so.
Please, my lords.
Serial number
It's
22,
22.
Vignesh Shetty for petitioner, KV Lokesh.
I served a copy to my lord, gave it.
You appear for the
Yes,
borrower.
my lord, it is quite difficult for me to appear in this side.
No, you shouldn't venture with this because I'll remember all your submissions this side.
Please, my lord, today also, my lord.
Yes. What is the prayer?
My lord, prayer, my lord, I am seeking setting aside the order made by the DRT.
Why you didn't go to DRT?
My lord, there's a apparent, my lord, fraud, collusion. There is, my lord, statutory aberration and, my lord, natural justice. There are
What is the
judgments, my lord.
DRT order?
My lord, it is set, my lord, page number, my lord, 93.
93.
My lord, before that, my lord, I'll point out, my lord, there are 5 points in this matter. My lord, my lord, being the borrower, my lord, against, my lord, the position notice issued by them, I approach the Honorable DRT. The position notice at, my lord, page number 52. My lord, approach the DRT, file an essay. Initially, interim order has been granted in my favor. And, my lord, I complied later, my lord, the DRT passed an order, partly allowed my application which I filed before the DRT under section 17. And, my lord, one scheduled property you can proceed further. The other, my lord, scheduled property, I can't, my lord, they can't proceed further. That was the order made by the DRT. I just point out the order passed by the DRT for a moment. Some, my lord, significance. Page number, my lord, 54. Not 54, my lord, start from 54 only, my lord. I'll operating portion of the order, my lord, page number 65.
Yes.
In the result of essay number 470 of 2023 is partially allowed. My lord, paragraph from 17 I am reading. IA number 2083 of 2023 is closed as per the following directions. The tribunal declares that the measures taken by the defendant under section 13(4) of the Act for taking symbolic possession of property prescribed item number 2 in the schedule on 26/9/2023 by virtue of annexure A5, possession notice is invalid, thus set aside. The defendant is permitted to proceed the further proceedings pursuant to annexure A5. Possession notice 26 in respect of the immovable property described in the item number 1 of the scheduled property, recovery of the secured debtors in accordance with the law.
No.
My lord, thereafter,
Why the court has held that part of the possession notice?
because there
part
is
of,
some CERSAI issue, I believe, my lord, in one property there is no CERSAI and other property some CERSAI is there. That is the reason I think, in fact, I am not challenging that order. It is, and my lord, they issued a sale notice pursuant to that in respect of one property. My lord can find it at page number 70.
This order is dated?
This order is dated, my lord, 31/12/2024. After 10 days of this order, my lord, they issued a sale notice in respect of one property.
Dated?
10/1/2025, page number 70.
Hmm.
Again, my lord, kindly come to the my lord, page number 70 for a moment. In the first paragraph, they said that 9 crore rupees loan I availed in the year of my lord 2016, and 3 crore 86 lakh. My lord can find it at paragraph page number in the page number 70, line number 4, 3 crore 86 lakh. And next paragraph, my lord, the next paragraph, they says that in the compliance of the rule 8(9) of the SARFAESI, we have fixed the reserve price of the property of rupees 6 crore 86 lakh. And my lord, the next para again they are saying that 4 crore 17 lakh is outstanding. My lord can find it, my lord, at page number 71. Against that, my lord, I approach the honorable DRT that my lord can find at page number 72. I have taken various grounds, including one of the grounds said that DRT set aside the possession notice. They ought to have been issued a press possession notice and all the condition which I canvassed.
That you have not
That is,
challenged.
I have not, that is,
Those issues.
that issues I
that
have
can't
taken.
be considered
I
in
agree,
essay.
I would, I'm not on that. I'm not at all on that. My lord, the honorable DRT, my lord, granted an interim order. My lord, kindly come to page number, my lord, 72, annexure J, 6th February 2025.
Page number?
Page number 72, annexure J. My lord, kindly come to my lord, page number 73. Sale issued by the respondent bank with respect to the scheduled property mentioned is appeal, which will be sold on 14/2/2025. My lord can find it at 11:30 AM. Recovery of sum of rupees 3 crore 86 lakh 87,902 from the petition appellant with future interest so and so so and so. Along with the main petition, the petition appellant had filed an interlocutory application so and so. My lord, I'll skip on that order. Page number 74. The sale of the scheduled property fixed for a sale on 14/2/2025 pursuant to the impugnated e-auction notice 10/1/2025 shall go on. However, the confirmation of such sale only hereby states subject to the condition that the petition appellant shall pay sum of rupees 96 lakh 71,975 within 1 month in 2 installment. The first installment so and so and 7 so. My lord, it is not in dispute. I'll just show you the, my lord, the order date, my lord, in fact, complaints of the order. I'll produce a copy to the same. The first page, my lord, I complied the order. It is got. I complied the order made by the honorable DRT.
Which order is assigned before this court?
My lord, final order.
Where is that?
That is, my lord, page number 71.
So according to you, you have complied with this order?
Not on that. My lord, this is, my lord, compliance is not on that. Compliance I completed, matter heard, matter posted for orders, order has been passed. There is separation of, I'll kindly bear with me, my lord, 5 minutes, my lord, I'll point out, my lord, what is a fraud taken place in this matter.
You cannot use fraud. The word
I will
fraud.
say.
If
Certainly,
I complaint,
I'll
if I
demonstrate.
committed fraud.
I'll demonstrate before this honorable court. Then only, my lord, before this, otherwise I would have no legs before this honorable court. I'll say. My lord, kindly come to, my lord, the order passed by this honorable DRT at page number, my lord, 2 of my memo which I filed just now. Both the counsel present, counsel for the appellant filed a memo having proof of the complaints of interim order and praise extension of having proof of complaints of interim order. I complied the interim order, it is not in dispute. My friend also will not deny it. And thereafter, my lord, matter adjourned time to time. On, my lord, 652, my lord, page number 4. Counsel for the respondent filed objections. Served the copy to other side. In fact, on that day, he filed the objections. And my lord, on 472, page number 5, counsel for the appellant praised extension of interim order, heard both the counsels, interim order is extended and shall continue till the next date of hearing for hearing 18/7/2025. Kindly see the page number 6. 6, my lord, page number 6. Heard both the counsel, my lord, I'm page number 6, my lord, can find order date 482000. Both the counsel are present. Counsel for the applicant pray for the extension of interim order passed by this tribunal. Heard both the learned counsel. Interim order is extended and shall continue till next date of hearing. For orders, reach the matter on 31/10/2025. My lord, on 4/8/2025, the Honorable DRT heard the matter at both the side after pursuant to filing their objections and posted a matter for orders. Orders on 31/8/2025. On the very, my lord, on after 3 days, matter posted for orders. On 7/8/2025, the respondent survey memo saying that I only purchased the property, bank himself. My lord, then I filed an application before the DRT at page number 7. My lord, I'll just point out, my lord, the conduct of the bank in this matter. My lord has to deal. Page number 7, I filed an application before the DRT. Kindly provide the detail. My lord, kindly come to paragraph page number 8. For the, my lord, in IA number 2066 of 2025. In fact, my lord, order has been already posted for orders. Thereafter, my lord, they're producing the details of the auction purchaser, saying that I himself purchased the property, bank himself. Wherein, my lord, my property is 20 crore. I'll demonstrate with the document. They fix the valuation for, my lord, around 7 crore odd. Recovery of 4 crore rupees, wherein 1 crore I already paid. 3 crore or less than 3 crore they ought to have been recovered. Then, my lord, I filed an application before the DRT saying that furnish the details of the auction purchaser, because it is my duty to either I have to bring him before the DRT or I have to, because it should be transparent. Bank, they can't sell it like whatever they want. They can't do it. Furnish the details of the. Then, my lord, kindly come to, my lord, order passed by the DRT at, my lord, page number 13. In fact, pursuant to IA, my lord, from 7 to 12, 13 is the order passed by the DRT. Both the counsel, my lord, order dated 9/9/2025, pursuant to I file an interlocutory application for advancement, even though matter is posted for orders, and application for produce the details of the auction purchaser. My lord, on 9/9/2025, the DRT passes an order. Counsel for the applicant filed an IA for advancement and prays for direct the respondent bank to furnish the details of the auction purchaser, details participants in the auction along with the bid sheet. Heard counsel for orders list matter on 31. My lord, here, my lord, the DRT again, my lord, directed them to, my lord, furnish the details of the auction purchaser, and my lord, posted a matter for orders on 31/10 as, my lord, which already, my lord, posted the date. My lord, it is not given any opportunity or nothing. Thereafter, my lord, the respondent gives the bid sheet to me. My lord, kindly come to page number annexure N 86, 87, 88. 88. My lord, I got it translated in English in next page, page number 90. Typed copy, not translated. Typed copy, my lord. Which, my lord, they're indicating I myself purchased the property. My lord, I'll just read if my lord permits, my lord, entire. My lord can find it page number 90. I typed copy of the, my lord, page number 84. 88. They produced pursuant to order by the DRT. I purchased the property. I'll just read it for a moment, my lord, in Kannada. ಹಣಕಾಸು ಆಸ್ತಿಗಳ ಭದ್ರತಾ ನಿರ್ಮಾಣ ಮತ್ತು ಭದ್ರತಾ ಆಸ್ತಿ ಜಾರಿ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಹರಾಜು ಮಾಡಲು ಮುಂದುವರೆದಂತೆ ಸಾಲಗಾರರಾದ ಸೋ ಇದರ ಪಾಲುದಾರ ಶ್ರೀಮತಿ ಕುಸುಮಾರ್ ಕೋಮ್ ಸೋ ಮೋಹನ್ ಸೋ ಬೆಂಗಳೂರು ಇಲ್ಲಿ ವಾಸವಿರುವ ಇವರುಗಳು ಜನತಾ ಸೇವಾ ಕೋಆಪರೇಟಿವ್ ಬ್ಯಾಂಕ್ ಲಿಮಿಟೆಡ್ ವಿಜಯನಗರ ಬೆಂಗಳೂರು ಪಡೆದ ಸಾಲ ಮರುಪಾವತಿ ವಿಫಲರಾಗುತ್ತಾರೆ. ಷರತ್ತು ಮತ್ತು ನಿಯಮಾವಳಿ ಒಪ್ಪಂದ ಅನುದಾನ ಮತ್ತು 4,17,79,4,17,17 ಎಂದು ಜೊತೆಗೆ ಅನ್ವಯವಾಗುವ ಬದಲು ಬಡ್ಡಿ ಖರ್ಚು ವೆಚ್ಚಗಳನ್ನು ಸೇರಿಸಿ ಸೆಕ್ಷನ್ 13 ಅಲ್ಲಿ ಅಡಿಯಲ್ಲಿ ನೀಡಲು ಅನುಸರಿಸಲು ಮತ್ತು ಚಲಾಯಿಸಲು ಬ್ಯಾಂಕ್ ನೋಟಿಸ್ ನೀಡುವ ಅಧಿಕೃತ ಅಧಿಕಾರಿ ಅಡಮಾನದ ಆಸ್ತಿಯನ್ನು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ ಮತ್ತು ಅದರ ವಿವರಗಳು ಕೆಳಗೆ ಸಂಪೂರ್ಣವಾಗಿ ವಿವರಿಸಲಾಗಿದೆ ಮತ್ತು ಭದ್ರತಾ ಹಿತಾಸಕ್ತಿ ನಿಯಮಗಳು ಸೋ ಕಾಯ್ದೆ ಪ್ರಕಾರ ನೆಕ್ಸ್ಟ್ paragraph, my lord, the property details. Finally, they are saying that, my lord, I have given authorization to my officer to purchase the property, and he purchased it in a piece of paper pursuant to the order made by the Honorable Debt Recovery Tribunal. My lord, thereafter, my lord, DRT passed an order at, my lord, page number 93. Just I indicate, my lord, I pointed out before this honorable court. I'll just draw my lord's attention. Page number 100. All the things are reiterated. Said that since already I held the matter in earlier occasion, therefore 13 to 13 for valid. My lord, I'll just read the order. Paragraph number 12. Assailing annexure A sale notice dated 10/1/2025. The appellant also contended that the defendant has not followed the procedures under the guidelines issued by the so as non-performing asset, and the security interest created over the scheduled immovable property is not registered with the so. It may be noted that all the contention was raised in essay number 470 of 2023 filed against the same defendants before tribunal, and the tribunal is adjudicated determine the issues while issuing so and so filed by so and so. Therefore, annexure A6 final order dated so and so has become absolute and final. The above circum in view of the principles of res judicata, the appellant is estopped from raising same contention against so and so. Paragraph number 13. Pending the proceedings of the defendant filed a memo on 7/8 that is, my lord, after posting the matter for orders before this tribunal stating that the secured creditor is auction purchaser in the auction held on 14/2/2025. In this circumstance and the view of the discussion as the above, it is found that appellant is not agreed by the recourse taken by the defendant under so and so in essay number 72 dismissed. My lord, now I have, my lord, my legal submissions are this. My lord, I availed the loan in the year of 2016.
No, before going into those submissions, first, initially, you have filed one essay or OA, whatever it is.
Essay.
In that you have raised the grounds with regard to the declaring your asset. as an
NPA
on-
13.2, 13.4,
everything-
all attain the
everything.
finality.
Then the tribunal has set aside.
I have not gone for an appeal.
Appeal.
I
So,
accepted
now-
the order.
Now, as far as those issues are concerned,
I can't raise.
You cannot raise.
I cannot raise.
So,
I'm aware.
And who is whether it is the purchaser is a bank, purchaser is a third
It is
party.
a bar under Act. That I'll
That's the
point.
only thing you have to
That I'll
argue.
point out. My lord, that I'll point out. My lord, kindly come to Banking Regulation Act 8, 9, 10. There is a bar, my lord. I am a custodian of the bank. That is the reason I came with the judgment.
Have it.
I'm a trustee. I can't purchase my own for my, that cannot be done.
That's the only ground.
I'll point out. I'll point out. My lord, kindly see before that, I'll point out the conduct, my lord. When they, my lord,
First of all, let
Please,
us
my lord, I'll point
complete with the provision.
I'll just point out. My lord, kindly come to, my lord, Banking Regulation Act 6.
You read in the meantime.
I'll just
You're
read.
searching for it.
I'll just read, my lord.
You have the book?
No, let him read it.
I'll give it to him. No problem. Forms of business in which banking company may engage. That is, my lord, I'll just keep it. It says that what bank can do. Then, my lord, come to my lord 9. Prohibition of trading 8. Notwithstanding anything contained in section 6 of any contract, no banking company shall directly
What is the tag called?
My lord, Banking Regulation Act 1949.
Yes.
Notwithstanding anything contained in the section 6 or any contract, no banking company shall directly or indirectly deal in the buying or selling or bartering of goods except in connection with the realization of security given to or held by it, or engage in any trade or buy, sell or barter goods for otherwise than in connection with bills exchange received for collection of negotiation or with such of its business as it's referred to clause I of the subsection 1 of section 6. I'll come to my lord 9 of the, my lord, section 9. Disposal of non-banking asset. That I'll come into that. Notwithstanding anything contained in any section 6, no banking company shall hold any immovable property, howsoever acquired except such as is required for its own use for any period exceeding 7 years from the acquisition thereof, or from the commencement of this act, whichever is later, or any extension of such period as in this section provided, and such property shall be disposed of within such period or extended period as this case may be. Provided that banking company may within a period of 7 years aforesaid deal or trade any such property for the purpose of facilitating the disposal thereof. Provided further, the Reserve Bank of India may in any particular.
You were reading?
My lord, section 8 and 9 of the Banking Regulation Act. My lord, there are certain restrictions for the bank to trade it.
Let me look at it.
Page number 6, 7, 8, 9, all 4 paragraph, my lord, relevant. The reason is, my lord, what are the things they can trade? Bank. Merely bank, my lord, I can't do whatever I want. there is an exemption to my lord 6789 under section 13(5)(a). My lord, my friend may say that we have a power under section 13(5)(a). I may permitted to read section 13(5)(a) for a moment. I may permitted to read section 13(5)(a). My lord, now they may say, I purchase a property under section 13(5)(a). I have a power recently that act inserted. When my lord, bank can also purchase the property. I'll just read the section 13(5)(a) for a moment.
Yes.
My lord, have a act, SARFAESI Act I'm talking about, my lord. SARFAESI Act.
You that I can do.
Where the sale of immovable property for which a reserve price has been specified has been postponed for want of bid of an amount not less than such reserve price, it shall be lawful for any officer of the securiticator, if so authorized by the securiticator in this behalf, to bid for the immovable property on behalf of the securiticator at any subsequent sale. B. Where the securiticator referred in subsection 5(a) is declared to be purchaser of the immovable property at any subsequent sale, the amount of the purchase price shall be adjusted toward the amount of the claim of the securiticator for which the auction is enforcement security interest is taken by the securiticator. My lord, I'll just pause for a moment. I'll just read the, again, my lord, two order I'll point out, my lord, petition copy. The order passed by the DRT in pursuant to my essay, where my lord, my 13(4) essay in the month of December, my lord, 31 December 2024. The sale assailed before the DRT on my lord 10 after 10 days of my lord, the order passed by the DRT. My lord, hence it's a first sale. Now I'll read my lord once again, my lord, 13(5)(a). 13(5)(a) says where the sale of an immovable property for which a reserve price has been specified has been postponed for want of bid. There must be, my lord, earlier auction conducted by the bank. The auction is not concluded because of for want of bidders. Subsequent sale for a want of bid for an amount not less than such reserve price, it shall be lawful for any officer of the securiticator and authorized the securiticator in this behalf to the bid for the immovable property. Now, my lord, kindly see 31(12), my lord, my 13(4) upheld, saying that you can proceed further in respect of one property. Within 10 days, they issued a notice. Then, my lord, it can't be second sale.
What is the stage now?
Stage, my lord, they issued the, my lord, sale confirmation has taken place. Even though I completed the interim order, DRT said that DRT is not looked into, even though I am not got an opportunity, whether who is the borrower, auction purchaser, and I am not.
So let him come up with his objections. It's a bank, no third party is involved.
Third party is involved, my lord. I have worried, my lord, the way which conduct in this matter. Kindly see, my lord. I'll show for a moment, my lord, my.
Oh, I understand. Ultimately, we have to pass orders. You have
If he's filing objection is fine. Otherwise, my lord,
I have only two submissions to make.
I have in a matter relegating before the DRT, that also I'm fine. Or if he's expecting some, because my lord, I am a my lord bona fide, my lord, I am not a thief here. I taken a loan 9 crore rupees. I paid already 13 crore rupees. I have, my lord, sufficient security. It is not that only one security. I have so many securities with them. There's the same matter which I argued. My photo published in the newspaper.
Or not only this client, all borrowers are not thieves.
I agree. My lord, I never said. I never argued, my lord. Allah, whether it is required to buy themselves, is it required, my lord? Allah, at least DRT would have given one opportunity for me.
For the interim order, there is no urgency for the reason that's with the bank.
If they're alienating the property, my lord. If they're alienating the property,
they will not alienate the property.
I have one submission to make, my lord.
To that extent, I can pass on.
Since 2019, account is NPA.
No, because
Lord, I have to make submissions, please, my lords, please, only for 2 minutes. I'll not take more than 2 minutes. A fraudulent borrower like this coming and commanding, don't talk, sir, please don't talk. I did not disturb you, please don't talk. A fraudulent borrower like this coming before court and making a bank as a fraud, alleging a bank as a fraud is absolutely illegal. Since 2019, except the orders of this court or DRT, not a single rupee has been paid voluntarily. Every cause of action has been taken as advantage. He will come before the court. Some conditional order is granted. He will not pay. He'll stop paying for 10 months, 1 year, 2 years. Since 2019, this is going on, and he chooses the forum cleverly, my lords. He chooses a forum very cleverly. You'll see where interim orders are granted, whether in DRT interim order grants are granted, whether High Court is not entertaining. If the High Court is not entertaining such matters, they will not come. They'll go before DRT. He's choosing forum as and when required, as per his convenience.
So now DRT appeal is allowed. In fact, 13-2, all arguments, 13-4 was challenged before DRT. Previously, with respect to the very same property, DRT told you sell one property, it was upheld, one property it was we are permitted to go ahead, which he did not file any appeal before any court of law. I issued sale notice. Lords, let him go, let him avail alternative remedy. I'm strongly on the alternative remedy, and he has not mentioned in his petition as to why he is bypassing the alternative remedy, and he's telling that this does not have any alternative remedy. So let him go before DRT. Let 4 weeks time may be granted. Let him go before DRT, my lords. He's telling that, in fact, his prayer only in this synopsis it is mentioned, and he is the person who he should be alleged for act of fraud, not the bank. So person like not only this case, he has more than 4 to 5 loan accounts with us. One property we have sold, and it is not under Article 300. He is claiming rights under Article 300, not for a person who is owning more than 100 properties in Bangalore. It's not he's a poor man who does not have any income. He's just taking bank's loan as an advantage and using the courts as per his convenience. And kindly look into when he wants to go before DRT, he'll go before DRT. When he wants to come before this court, he'll come before this court. At that point of time, this court was not entertaining any appeal under sale notice was not entertained. Then he went to DRT. There are multi number of cases where interim orders were granted by this court. 2 to 3 years, the matter was dragged on by this person. Now he's coming and telling bank is fraud. I'm just recovering my money. Let him be relegated to DRT. Let 4 weeks time may be granted. I'll not precipitate the matter for next 4 weeks. So let him go before DRT.
Produce a compilation of judgment. This occasion, this Honorable Supreme Court considered, my lord, I may produce certain judgments.
The present writ petition is filed, seeking the following relief. Land counsel appearing for the appellant, the petitioner borrower submits that the bank has purchased the property, and contrary to the SARFAESI Act provisions of the
Section 13(5)(a),
13(5)(a)
and
of the
13(5)(b),
SARFAESI Act
and
and the
banking
Banking Regulation Act, Section 6, 7, 8, 9 of the Banking Regulation Act. It is submitted that the bank being a trustee, and when the auction, being the first auction, they cannot purchase the property. And according to the counsel for the petitioner, there is a fraud played by the bank. Next, learned counsel appearing for the respondent bank submits that the writ petition is not maintainable. He has to go before the DRT. Several times he went before the DRT. Right from the day he has approached several forums and obtained several orders, and he has not paid a single part. And in fact, one of the property of the petitioner is auctioned by the bank. And there are no, when there is an alternative remedy available to the petitioner to approach the DRT, he has come before this court, and the writ petition is not maintainable. Next paragraph. According to the petitioner, there is a fraud played by the bank. When the fraud is alleged and the same is not considered by the DRT, even when there is a remedy of approaching the DRT, in the light of the settled law, this court can still consider, and under 226, this court has a jurisdiction to consider the writ petition. Then coming to the interim order that is sought by the petitioner, as the bank, the property is with the bank, and the property and the bank is the owner of the property. In the considered opinion of this court, at this point of time, no interim orders needs to be passed in this writ petition. After the objections are filed by the bank, this court will hear the matter in detail, and then will finally dispose of this matter. The respondent bank shall file its objections by 26th of November.
First week of December.
26th of November, list the matter on 2nd of December.
Grateful. My lord, I have some certain judgments, my lord, in this regard, in a very similar set of facts. Am I permitted to file?
Every day now, we are all seeing those judgments, not necessary now. We'll see when required.
Grateful. I may permit to file it, my lord. I may.
You can file in the section.
Grateful.
The registry.
Grateful, my lord.
Next,
Sale number, admission matter, sale number 23.
In copy.
23 Guru Prasad KT, Uday Prasad.
Liability is on the owner. Notice.
Notice to the respondent.
Cell
Yes,
number
24.
24.
I am for appellate. Case of associate has not been provided.
Notice to the respondents, 25.
Cell number 25.
Notice,
Cell number 26.
notice.
My lords, 26, I seek dispensation to R1, my lord.
Dispensation to R1, dispensed with R2.
Lords, R2,
Huh?
if
Reliance General.
Reliance, my
Pradeep
lords.
is directed to take notice on behalf of the insurance company. No delay? No delay?
No delay.
No delay, my lords.
Admit file in TCR.
Cell number 27.
The notice to R1 can be dispensed.
Memo is filed for dispensation of notice to R2 dispense with R1.
United India.
Huh?
United India.
R2.
Mr. Egde Mulkondo.
Hmm?
Mr. Egde Mulkondo.
Mr. Mulkund is directed to take notice
Yes.
on behalf of the insurance company.
Yes.
Admit file hearing TCR.
Matter may be referred to Lok Adalat.
Then no file hearing. Matter is, matter is referred to the Lok Adalat. Yes, next.
Please.
Come to the pass over matters.
Passover matters in list number 1, serial number 135.
Yes.
Stock and Patil MB
That's for
right.
the appellant in this case, my lords.
Yes.
After fee and recovery may be added, so far respond number 2 is concerned.
Then what about
And the
the,
quantum, my lords, in only one matter, my lords.
please give me the table.
Please, my lord.
MFA 1091, you should have some MFA 1091 arising out of,
My lords, I have, my lords, I'll pass on this.
please give. MFA MB 1091 against MBC 118. Let's see where is MFA 118. Yes, page number 118 table,
Page
118,
number
my
38, my
lords.
lordship.
page number,
38 of the improved judgment.
paragraph number,
Paragraph number 43, my lordship.
table at 43. So how many are the injuries?
But in this case only, my lords, I am challenging quantum. My lords,
So we are calculating how many
Please.
injuries, how many
my lords,
grievous
there
injuries?
are here's, my lords, fracture of left tibia and fibula.
Hmm.
And fracture of right tibia and fibula, my lords.
Hmm.
The doctor has deposed, my lords, at the,
So pain and suffering, there is 75,000.
75 is granted, my lords.
So then medical expenses, where are they? No medical expenses,
My lords, it is not, my lords.
pain and suffering. Then how many days he was in hospital?
9 days, my lord.
Incidental expenses. Nothing is granted?
No, my lords, it is not.
9,000. Then loss of income during laid up period.
87,000 is granted.
6
my lords.
months.
For 6 months, it is granted, my lords.
How many days was in hospital? 9 days.
9 days, my lords.
6 months is on the highest.
3 months, my lords, could be granted.
4 will grant.
Please, my lords.
Which year is the accident?
But it is-
2021, my lordship.
21. 15,000 into 4. 60,000. 60,000. Then
Loss
what
of,
about the loss of future income? According to the doctor, what is the disability?
Doctor has stated that, my lords, it is 42% to the left lower limb and 30% to the right lower limb.
Hmm.
And the tribunal has taken, my lords, at 35% to the whole body,
No. So 30% to the,
42% to the left lower limb, and, my lords, 30% to the right lower limb.
1 divided by 4. It's 7.5%. Then 42 into 1 divided. Is 14%. 14 plus 7.5 is 21.5. Tribunal are taken,
35%, my lords, to the whole body.
Please, my lordship.
that will make it 21.5. That's what it is,
Please.
as per the evidence.
1/3.
So 21.5, we'll make it 22.
Please.
When it is 22, future prospects.
Please, madam.
Yes.
So 15,000, what is the age?
55 years.
55, 10%, my lords.
That is 1,500. Comes to 16,500 into 12. What is the multiplier?
11, my lords.
Huh?
11.
11 into 22. It's coming to 4,79,160. Court had taken how much you said?
35%.
35%.
Then amenities,
Amenities 50,000 awarded, my lord, only.
let's continue that.
Please, madam.
My lord, there is a, my lord,
Future treatment, my lords, 50,000 is awarded.
right and left, my lord, fibula and tibula fractures, at least another 50,000, my lords.
Future treatment, what was evidence?
That's evidence.
Future treatment awarded, future treatment, my lord, 50,
The two operations it's required.
please, my lord.
Huh? We will grant another 10,000, 60,000,
10,000, my lord, is very.
30. So it's coming to 7,33,160 against 9,31,900.
Please.
You have not preferred any appeal?
No, my lord.
So next coming
That's
to.
in next matters, my lords, I am not pressing on the quantum, my lords. It is matters reasonably avoided. In all three matters, my lords, the quantum may be confirmed, my lords, with pay and recover.
Yes. So what we do is only this matter, I'll give a separate dictation, remaining other matters.
Please.
Agreed with award passed in MEC number 118 of 2022. The appellant insurance company is before this court, questioning the quantum as well as the liability. The tribunal, the claim petition is filed, seeking compensation of how much in this?
9 lakhs,
Seeking compensation of 9 lakhs for the injuries sustained with the claimant.
9 lakhs 31,900, my lord.
No, claimed.
Climate compensation, sorry. Climate compensation,
The claim petition is filed, seeking compensation for the injuries sustained by the claimant. The tribunal has awarded the compensation as per the table given below, at paragraph number 43. When it comes to the liability, the tribunal has held that. Where is that?
That's at para 57, my lords, in page 55.
The
My
tribunal
appeal, ma'am.
has held that the owner of the insurance company alone is liable to pay the compensation. When counsel appearing for the insurance company submits that the driver of the offending vehicle was not possessing a driving license and he was not qualified to hold the driving license and he violated the terms and conditions of the policy.
But he was holding only a learner's license.
He was holding a learner's license and he was without
Person with,
he's driving without the presence of a person who is having a regular a license to drive the vehicle. As such, there is violation of terms and conditions of the policy, and it is the owner who is liable to pay the compensation, but not the insurance company. When it comes to the compensation, it is submitted that the tribunal, under the head of loss of future income, had taken the disability at 35%, when it is evidence of the doctor that there is 42% disability to the uh, to the lower limb and 30% to the disability to the no 30% disability to the upper limb and 42% disability to the lower limb. Court ought to have taken 35%. It is submitted that the amount of compensation that is awarded by the tribunal is on the higher side. Next part. When counsel appearing for the respondent insurance company, the respondent claimant submits that the court had rightly granted the compensation, there are no grounds to interfere. Next, when counsel appearing for the owner of the vehicle submits that the court has rightly fixed the liability on the insurance company and no interference is called for. Next, having heard so and so. First, coming to the aspect of liability, the driver of the offending vehicle was having a learner's license. And the violation is that there was no, the other person who's like having the license is not accompanied this person. And so, according to the insurance company, they are not liable to pay in the light of the settled law. In spite of the same, in the light of the law laid down in Swaramsing's case, still the insurance company is liable to pay and record the same from the owner of the vehicle. Coming to the compensation, considering the injuries that are sustained by the claimant and the head of pain and suffering, court had rightly granted 75,000. Towards incidental expenses, he was in hospital for 9 days. No amount is awarded. Hence, this court is granting 9,000. Coming to the loss of income during the later period, court had considered for 6 months. This court is granting for 4 months, 15,000 into 4, 60,000. Coming to the loss of
14,500 minutes, it is of the year 2020 accident. 14,500 needs to be. 2020 minutes, accident is of the year 2020. I'm sorry, minutes. I did not point
What
out.
is this, Mr.? You keep quiet when the court is
I
calculating.
was under the impression this
Not
21.
impression because I was loud enough to say that. Now again, everything I have to do. No, even in this. It comes to 7,668,000. What did you write? Coming to the loss of future income. During the later period, 14,500 into 4, 58,000. Coming to the loss of future income. The court, the court ought to have taken the disability at 22%, as 30% disability is to the upper limb. 1/4 of it will come to 7.5, and the lower limb disability is 42%. It comes to 14%. It is 21.5. Hence, this court is taking 22%. 14,500 plus future prospects at 10%, 1450. It comes to 15,450 into 12 into 11 into 22 by 100 is 4,48,668. Towards amenities, 50,000. Future treatment, considering that he has to undergo 2 operations, 60,000. Altogether, the claimant is entitled for 7,668,000. Accordingly, the appeal of the claim insurance company is partly allowed by reducing the compensation from 9,31,900 to 7,668,000. The amount in deposit shall be forthwith transferred. The amount insurance company shall pay and require the same from the owner of the vehicle. If any excess amount is deposited, the insurance company is at liberty to withdraw. Now, coming to the other petitions. Agreed with award passed in. This is a common order. Agreed with award passed in MVC number 119 of 2022. The insurance company has filed 1092 of 2024. MVC 108, 1088 of 2024. 109 of 2022, 1099 of 2024. The tribunal has disposed of the appeals by way of a common order. As such, this court is also passing the following order. In the other matter, whatever is with regard to the liability, then counsel for the appellant insurance company submits that when the same learner's license and all, the insurance company is not liable. Both the contentions as it is. Accordingly, the appeal of the insurance company is partly allowed, holding that the insurance company is liable to pay the compensation and require the same from the owner of the vehicle. In all the matters, the amount in deposit shall be forthwith transferred. Yes.
List number 2, pass over list number 2, serial number 2. List number 2, serial
What
number 2.
about the income in this, Mr. Ravi?
Lord, in this, the tribunal has considered 17,500 income.
Base, that is a basic salary.
Yes, ma'am. The heads on which the salary, according to them, he was earning a sum of rupees 31,756. The basic salary is 17,500. HRA is 7,000. 2,300 is the conveyance. LTA is 1,250. And 1,250 is towards medical reimbursement. 2,646 is allowance, other allowance. They have not specified with regard to on which head. My submission to the Lordship is the LTA cannot be considered as a part of the salary. And so also the 2,426, the amount which is towards grant. Those two heads cannot be considered.
You that TCR you have shown that the salary slip.
P16, sir.
P18, P17, 17. P17. 17 and 18.
So we have to take 17,500
Plus 7,000.
7,000
Plus 2,300.
2,000.
2,300 towards conveyance.
Conveyance is 1,600. House rent level 11 7,000. Conveyance allowance is 1,600.
I'm sorry.
So 1,600. Then
LTA 1,250.
No. Medical reimbursement is 1,250.
And LTA is also there for 1,250.
So both we have to take 1,250.
1,250 towards LTA is cannot be considered. Then 2,426 which is towards the other allowance. Only two heads which has to be deducted, my lord. One is LTA 1,250.
1,250.
And 2,426 towards other allowances.
Where do you get that?
I have noted down from the exhibit.
No. I have the exhibit with me, 81. It says basically 17,500. After that, house rent 11, 7,000.
Yes, ma'am.
That we have added.
Yes.
Medical reimbursement 1,600. After that, leave travel allowance is 1,250.
1,250.
Food coupons.
Some city
Medical
compensatory.
reimbursement and leave travel allowance around 1,250, 1,250.
1,250 is medical allowance, medical reimbursement.
City compensatory allowance is 3,169. What is that? So if we take this 1,600 and 1,250,
Lord, your Lordship may kindly turn to the next page, my lord,
Next.
where there is a,
Hmm.
the monthly basic salary is 1,750, 17,500,
Yes.
HRA 7,000,
Hmm.
conveyance 2,300, LTA 1,250, medical reimbursement 1,250,
Hmm.
other allowance 2,456.
Hmm.
Lord, my submission to order 2,426 and 1,250 request to be deducted from the total income of 31,756.
It's coming to 28,050.
28,000 can be considered.
What is the age?
It is aged around
30 years.
30 years, 17 multiplier.
Future prospects 40%.
Yes.
It is coming to 39,270. How many are the dependents?
There are two,
Hmm?
mother and brother, my lord.
Two.
Roughly
50%.
50%.
He's a bachelor.
That's it.
Then it is 19,635. Into 12 into what is the multiplier?
17.
17.
17. It's coming to 40 lakhs 05540. Consortium
Consortium only
2
25.
into 2. 2 or 3?
What, Lord, mother is
Mother
the
and
claimant.
brother, my lord.
Mother and brother.
Real consortium.
2, 2.
2, my lord.
2 into 44. It's coming to 41 lakhs 39,540 against
25 lakhs 54,000.
30?
25 lakhs
25
54,000.
lakh 54,000.
55 lakhs 50.
4,000.
Court had taken the income at
17,500.
Basic salary is considered.
Please come. Agreed with the award passed in MSc number 7643 of 2018, date 11 February 2021. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at paragraph number 20. Then counsel appearing for the claimant submits that the salary of the claimant is 31,769. He has examined PW2 in this regard, but the court had taken the salary at 17,500, which is on the lower side, and the compensation needs to be enhanced on all other grounds also. Then counsel appearing from the respondent insurance company submits that there are no grounds to interfere, and the court has granted a just and reasonable compensation. This is, now what we're doing is exhibit
P17. Page number 2 of P17.
The exhibit P17, page number 2, next to having heard so and so. First, coming to the aspect of the salary, the claimants have produced a salary slip. Exhibit P17, page 2 of the same, contains the details. The basic salary is 17,500, HRA 7,000, conveyance 2,000, LTA 1,250, monthly performance medical reimbursement 1,250, and other allowances 2,456. The court ought to have taken the basic salary, HRA, conveyance, and medical reimbursement.
Medical reimbursement, well, the only heads under which the
No, 1,250 is medical and LTA also.
LTA.
LTA shouldn't have taken.
Yes. LTA and other allowance.
LTA and as per that so and so, except LTA, other allowances, court ought not to have considered. If the other element, the basic salary, HRA, conveyance, monthly performance incentive, and also medical reimbursement are considered, the salary is 28,050. As he is aged 30 years, 30?
30 years.
30 years, future prospects at 40% will come to 11,220. Then the salary is 39,270.
Well, at one small profession tax of 200 rupees to get deducted, which is
It's
not.
not here,
It should.
but it is not, they have
It's
not
not in the
deducted.
list. It is
No,
not.
they have not deducted it.
They are not.
So it comes to 39,270. As he's a bachelor, 50% has to be deducted. Then his contribution to the family is 19,635 into 12 into 17. To his loss of dependency, 40 lakh, 5,540. Consortium, 2 into 44, 88,000. Funeral expenses, 36. Legal expenses in the light of so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 41 lakh 39,540. Accordingly, appeal is partly allowed by enhancing the compensation from 25 lakhs 54,000 to 41 lakhs 39,540. The enhanced amount shall carry 6% interest. Any delay in this?
Delay, 573 days delay, which was
573 days. Now condoned or to be condoned?
it's condoned on 25, 25, 5, 24.
Yes, it should reflect in the order.
Applies.
Yes.
Continuation of list number 1, serial number 8. List 1, serial number 8. On list 2, serial number 8, Gopal Krishna N.
No representation on behalf of the appellant list this matter in the month of January.
Last time also they have taken adjournment, Your Lordship, on the last date of hearing also.
This is in the month of January. 9.
Serial number 9. Serial number 9,
For the
Uday Prasad.
for the two connected appeals, both are case of injuries.
MFA is arising out of 2095,
2095, 3029 of 21,
30.
29 of 21, MAC 3029.
The other one,
Other one is 3028 of 20.
MFA 2092. So first we are dealing with MFA 2095.
Yes.
Where is the table?
Last portion.
Para number?
Para number 18. Para number 18 is the injuries. Table is at para internal page 17.
Yes. Table at para 22. What are the
He
injuries?
suffered mild head injury, displaced fracture of the right ulna, right eye full thickness tear, scalar tear, its prolapse, open globe injury, etc. 5 days he was in the hospital.
No. How many grievous injuries?
One fracture and 3 injuries.
Or they are not grievous injuries? Only one fracture.
One fracture is grievous injury and the other 25,000.
50,000 for pain and suffering. How many days was in hospital?
5 days he was in the hospital.
5,000.
15,000 is awarded. 555.
But that's on the higher side. Anyhow, 15,000.
Yes.
If it is we are enhancing on other heads, then I will reduce it later. Yes. Then loss of income during later period.
3 months. Only 14,000 is granted.
Which year is this?
2021.
15,000.
Yes.
15,000 into 3. That's 45,000. Yes. Then
As disability is concerned, 39% to the limb and 13% to the whole body.
what is the evidence of the doctor?
The PW2 doctor,
What did he say?
he says 39% to the limb and 13% to the whole body.
Court had taken?
Court has taken only 10%.
What do you say?
My lord, as per the chart, it can be taken the income. And my lord, disability, my lord, the
No, not income, disability. 39 into 1.
13%, my lord, the doctor
We
says.
will take 13%. Yes. So 15,000 loss of future income. 15,000 into 12, what is the
18,
multiplier?
18.
18 into 13 by 100. Yeah, court has taken income at
14,000, madam.
14,000.
14,000, 10% disability.
To 12 to 18 into 13. It comes to 4,21,200.
Yes.
Then amenities, how much is granted?
Amenities 5,000.
5,000 has been given.
Disability is 18%, 30,000 will grant.
Future
Then-
medical expenses.
How many surgeries? One?
Is.
Only one fracture, must be
Only
one
one fracture.
surgery.
10,000 is our red.
30,000 will grant.
Yes,
Medical bills as it is.
as it is.
1,79,000. Now, we will reduce this conveyance charges. How many days you were there in hospital?
5 days.
So we are take 5,000.
5,000 has been given, madam.
15,000 is given. If you are okay, I will again add it.
Conveyance attendant loss nourishment.
It's coming to 7,70,200. Against 5,50,400. Now come to the other one.
5,51,000, rounded up to 51,000.
51,000.
The other one is a chart at internal page 13.
That is now MBC 3028 of 21. MFA 2092.
Yes.
Where is the table?
Internal page 13. 13.
Paragraph?
Paragraph 16.
Yes.
Injuries are at
Yes, what about this?
a mild head injury, fracture mid shaft of right femur, and fracture proximal phalanx left thumb, 2 fractures.
2 fractures. So, head injury also.
Yes.
60,000. Yes. How many days was in hospital?
7 days.
Huh?
7 days.
7 days.
Incidental expenses 7,000. Yes.
PW 3.
Loss of income
14,000 has been granted.
during laid up period. So same like in the other case.
Same.
15,000.
15,000.
15,000 into 3. 45. Then few, no medical expenses.
Already reimbursed, madam.
Reimbursed.
So, pain and suffering, food nourishment, conveyance chart, and then coming to the loss of future income.
Yes.
According to the doctor, what is the disability?
47% to the body and
To the?
limb and 16% to the whole body.
47% to the lower limb.
Yes.
Uh,
16% to the whole body.
Court had taken?
10%.
Huh?
10%.
It should be?
Doctor says, madam, whole body is 16%.
1 divided by.
1/3 of 47%.
It comes to 16.
Yes.
We will take 16. So,
15,000.
15,000 into 12, what is the multiplier?
18.
18 into 16. 5,18,400.
Yes.
Then loss of amenities,
7,000 is.
amenities 30,000. Future medical expenses,
10,000 is for 2 fractures.
30,000.
Nourishment conveyance attendant,
I have granted 7,000.
21,000 is.
So on the higher side, we are increasing the others. It's coming to 7,400,000 against 3,90,000.
90,000.
Like 90,000.
Huh?
3,90,000.
Any delay in both the cases?
614.
In which case? First case?
2095. In both the case, same delay.
How much?
614.
614. Same one order. Agreed with the award passed in MBC number 3029 and MBC number 3028 of 2021 dated 18th April 2022. The insurance company, the claimant is before this court seeking enhancement of the compensation. The tribunal has disposed of these two appeals by a common order. Hence, this court is also passing a common order. In that, MFA 2095 arising out of MBC number 3029 cited it, of 21. The tribunal has granted the compensation as per the table given below, that is at paragraph number 22 of the order. The learned counsel appearing for the claimant submits that the tribunal, under the head of when he has sustained grievous injuries under the head of pain and suffering, had granted only
25,000.
had granted only 25,000. Even under the for the loss of income during the later period, only 14,000 is granted. Further, the court had taken in the income at 14,000 instead of 15,000, as accident has taken place in the year 2021. But under the head of future medical expenses, amenities, the court has not granted a reasonable compensation. It is submitted that when the doctor has deposed that the claimant had sustained 39% limb disability and 13% disability to the whole body, the court had taken 10% instead of 13%. Hence, on all these counts, the compensation needs to be enhanced. When counsel appearing for the respondent insurance company submits that the court has granted just and reasonable compensation. No enhancement is called for. Next part. Considering the grievous injuries that are sustained by the claimant and the head of pain and of suffering, this court is granting 50,000. Coming to the incidental expenses, he was in hospital for 5 days. Court had granted 15,000. Court had granted 15,000. However, this court is granting only 5,000. Loss of income during the later period, considering the hospitalization and the injury for 3 months, 15,000 into 3, 45,000. Loss of future income. When the doctor had deposed that the limb disability is 39% and the whole body disability is 13%, without any basis, court has taken 10%. And this court taking the income at 15,000 into 12 into 18 into 13 by 100 is 4,21,200. Towards loss of amenities for disability of 18%, 30,000. Future medical expenses, this court is granting 30,000. Medical bills as granted with the tribunal. Legal expense in the light of the so-and-so 10,000. Altogether, the claimant is entitled for an amount of rupees 7,70,200. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 5,51,000 to 7,70,200. The enhanced amount shall carry 6% interest. Next, MBC 3028, MFA 2092 of 2024, arising out of MBC number 3028 of 2021. In this paragraph number 16, The tribunal has granted the compensation as per the table given below at para 16. The tribunal, the claimant had sustained how many injuries?
2 fractures.
Sustained 2 fractures and the fractures. Counsel submits that the claimant has sustained 2 fractures and the pain and of suffering, the court has granted only 35,000. Further, under the head of loss of income during the laid up period, only 1 month is granted, but considered 14,000 instead of 15,000. Coming to the loss of future income, it is stated that the doctor has deposed that the disability is
47%.
40?
47% and
47% and 16% to the limb, but the court had taken
10%.
10%. He submitted that for the future medical expenses also, the amount that is awarded by the court is not just and reasonable. Same contention for the respondent. Considering the fracture injuries and the head of pain and suffering, this court is granting 60,000. Incidental expenses as he was in hospital for 7 days, this court is granting 7,000. Coming to the loss of income during the laid up period, 15,000 into 3, 45,000. Loss of future income. When it comes to loss of future income, court ought to have considered 16% as per the doctor and doctor, hence 15,000 into 12 into 18 into 16 by 100 is 5,18,400. Loss of amenities for disability of 16%, 30,000. Future medical expenses 30,000. Legal expenses in the light of so and so. Altogether, the claimant is entitled for 7,04,000. Accordingly, the appeal of the claimant is partly allowed and enhancing the compensation from 3,90,000 to 7,04,000.
Delay.
In both the cases, the delay of 614 days, they are not entitled for the interest.
But one observation stating that, my lord, we have supported the judgment of trial court.
The land counsel for the insurance company submits that already they have satisfied they have deposited the entire amount and satisfied the award.
No, so we are justifying the trial court order. That's what.
I have already said so.
Obliged.
Without you asking in every order, I will write that. No, this you don't write.
Not
This.
necessary.
Yeah.
Cell
Yes.
number 10, Pramodar for appellant, T.N. Malaji.
Case of injury, my lord.
Where is that? Where is the table?
Para number 70, page number 17 of the judgment, my lord.
Page number?
17 of the judgment, my lord. Fracture of right hand wrist and fracture of 7th rib of the chest, my lord. She has sustained and
Where is the table?
page number 17, my lord, of the judgment, my lord.
Paragraph number 7.
Page number 17.
Yes.
Towards pain and suffering, 10,000 is awarded. 2 fractures, my lord. Fracture of right hand wrist and fracture of 7th rib, my lord. She has sustained. She has aged about
Pain and
55.
suffering 50,000.
Your lordship, she was treated with POP application. No surgery was conducted. And
He will have the pain. For pain, it doesn't matter. Next. Medical expenses nil.
Government hospital
Government
taken. And diet, food and nursement, 5,000 is granted, my lord. And loss of future earning capacity is.
Incidental expenses, no enhancement called for.
Yes, ma'am.
5,000. Then loss of income during later period. This needs to be enhanced.
Yes, my lord.
6,000 has been considered and as per.
Which year is the accident?
2015, my lord.
2,000 is to be
Which year is this?
2015, my lord.
15.
9,000. 9,000 into 3. 27,000. Then
My lord, loss of earning capacity, my lord, future earning, my lord.
according
my
to
lord,
the doctor, what is the
my lord,
disability?
in this case, my lord, we are paid 6,000 for income, my lord.
Huh?
We are paid the 6,000 income.
You have paid only 6,000. So
6,000.
Yes, court of.
we'll grant for 4 months,
Yes, my lord.
24,000.
Yes.
Then
My lord, as per the loss of future
Disability?
earning, my lord, future earning capacity, yes, court has taken rightly, my
Rightly.
lord. 6,000 and 12% is taken, my
the
lord.
loss of future income as it is.
Yes, my lord. Amenities is, my lord.
1 minute, we'll see. Loss of future income, 95,040. What is the disability according to the doctor?
37% to the limb and 12% to the whole body, my lord.
Court had taken 12%.
12%.
So loss of amenities, 30,000. No, you said how much is the disability? 12% to the whole board.
12%.
So loss of amenities, so all other future medical expenses nil? Yes. Legal expenses, 10,000. So it's coming to 2,14,040. How much is granted by the court? 1,20,040. Yes, please come.
Your Lordship, charge sheet is filed as per section 185 of MV Act and pay and recovery has been ordered by the court.
Already ordered.
Yes.
This is MBC number 30.
6, my lord.
Agreed with award passed in MBC number 306 of 2015, dated 21st June 2022. The claimant is before this court. Any delay?
539 days.
539. Agreed, 306 of 2015, dated 21st June 2022. The claimant is before this court seeking enhancement of the compensation. It is on counsel appearing for the applicant submits that the tribunal, when he had sustained the fracture injury, court had not granted a reasonable amount under the head of pain and suffering. Even under the head of loss of income in the later period, also the court has later period and the amenities, the amount that is awarded by the court is not a reasonable compensation. And on all these heads, the compensation needs to be enhanced. Next parallel, counsel appearing for the respondent submits that the tribunal has rightly granted the compensation and rightly fixed the liability on the rightly applied the principle of pay and recover, and there are no grounds to interfere. Next, for having heard the counsels on either side, there is a material non-record. Considering the fracture injury sustained by the claimant and the head of pain and suffering, this court is granting 50,000. The incidental expenses, as he was in hospital for 5 days, 5,000. Loss of income during the later period, as it is the case of the claimant that is earning is 6,000. 6,000 into 4, 24,000. Loss of future income, court had rightly granted, no interference is called for. Loss of amenities or concern concerning 12% disability, this court is granting 30,000. In the light of so-and-so legal expenses, 10,000. Altogether, the claimant is entitled for 2,14,040. Accordingly, the appeal filed by the claimant is partly allowed, enhancing the compensation from 1,20,040 to 2,14,040. Delay 539 days. He will not be entitled. Then as pay and recover. Enhanced amount shall carry 6% interest.
Number 11. Nagaraj Reddy.
Case of injury, my lords.
Tamilji.
Claimants appeal seeking enhancement. Claimants appeal seeking enhancement, my lords. Case of injury.
Where is the table?
Yes, my lords.
1/2/22. Date of accident 1/2/22.
Table. Which is the MBC?
1386. 3186.
No.
3186.
There are only
1386.
86.
No DL as on date of accident, my lordship. Pay and recovery is also. Owner
It is
also.
ordered pay and recover.
It is already altered.
So nothing on that.
Owner also paid 4 lakhs. He also contested. Insurance
So,
company not liable.
Where is the table?
Lords, there is no table.
So where is
number 23.
Let's come to your synopsis.
Yes, my lords. But pain and suffering, lords, 25,000 is ordered.
1 minute.
The date of accident is 1/2/2022.
I'm not able to find in your.
Lords, this is page number 1, lords, synopsis. Immediately after index.
What are the injuries?
Lords, there are three fractures and Lords, the appellant was being a pregnant lady, Lords, lost her 9 months old baby in the accident.
Lost?
Yes, yes. Lords,
Yeah,
three
fine,
fractures,
separately.
left femur fracture.
For that, there is another MVC for in that.
Yes, yes, that is
Confirmation has been
granted.
allotted.
No, no. In this case, I am asking.
Yes, Lords. For
In
the
this
baby,
case-
Lords,
In
separate
case of
was filed and
femur
there
fracture, my
250,000
lordship,
was granted.
There is only one fracture.
No, three fractures.
PW2, one doctor assessed the disability is 50%.
Lords,
But,
left femur fracture, pubic knee fracture and neck fracture. There are three fractures.
Yes.
He assessed the
Doctor
disability.
has assessed Lords, 50% of the
60,000.
limbs and
Medical. Please come to your synopsis.
yes, Lords.
It will be easy for the court.
Please. Pain and suffering, 25,000 is granted.
We'll grant 60,000.
Medical expenses as it is Lords. Laid up
Loss
period,
of income during laid up period.
only 7,000 is granted. She was hospitalized for 9 days.
Which year is this?
22 minutes.
How many days hospitalized?
9 days. Minutes. Amenities, 10,000 was granted.
What is the disability?
Disability Lords, doctor has assessed 50.75% to the limbs and
50 point?
7.75 and 25.
15 or 75?
75. 5075.
To the?
Limbs.
My lord,
And Lord, for the
a
whole
PW2 assessed the disability 50.57. 50%, 25%, 28%. Tribunal taken is only 15%. He is not assessed the limb. Yeah, 15% is correct.
Let's see. Where is the top?
Page number judgment 21. my lord.
Para 32.
21.
Page number 21, para 32.
Para 32. You know. But PW2 doctor is not a treated doctor. Only assess the disability, my lordship. Disability also higher side.
Court had taken how much?
15%.
15%, 1.5.
Para number 35.
Where do you get that? Not in this paragraph case.
Lords, ink page 31 and paragraph number 35 and running page 22 of the judgment.
Petitioner has sustained disability, but the assessed disability by the doctor cannot be taken into consideration.
This is the only.
The PW2 has not divided the whole body disability into 1/3 of for both disability. I feel it just and proper to consider. Where is that?
35.
Where do you get that?
Doctor's assessment.
Page 30, paragraph number 32, only 3 lines.
That PW2 had assessed the permanent residual physical disability of left lower limb. Yes, limb disability is assessed.
Judge, page number 22, my lord. 32.
According to him, limb disability is 50.57.
15%.
50.57, not 15, 50. 50.57 is a limb disability.
Yes, ma'am.
1/3 has to be calculated.
Yes.
Court has, it comes to?
Court has taken 15% Lords, it comes to around 17%.
50.57.
75.
Hmm?
50.75. Sorry.
1.5.
57. I'm sorry. It is 5. I'm sorry. Miss.
It comes to 16.8, that is 17.
Court has taken 15 minutes.
We'll say
And the
17.
income considered Lords is 13,311.
13,000?
311.
Why?
No, it is.
She is
it
cool.
said Lords, it is a
Coolie work.
Coolie work. So loss of future income.
2022 accident.
So 15,500
yes, ma'am.
into 12 into what is the multiplier?
18 years, 23 years.
18 into 17 by 100. It's coming to 5,69,160. Then loss of amenities, how much is granted?
10,000. 10,000.
30,000.
But there are 3 fractures and it is.
Future operation, what is granted?
Future medical.
Future medical is 15,000.
Another 15, 30. Legal expenses, 10,000. Coming to 9,59,258 against
6,86,374. 6,83,086.
86,000.
It is in page number 35.
64.
In page 35.
page number?
Ink page 35, lots at the top.
Six lakhs 86,000
374.
374. In your synopsis, that is not even calculated.
It is stated.
Any delay?
No means no delay.
Yes,
No DL as on date of accident.
that's a new,
Owner also-
that is not in question.
You already filed 4 lakhs owner. Remain
Yes, sir.
balance also divide. the
After
amount.
paying by the insurance
Insurance company
they
not
filed
like-
execution in which they have paid the amount to
Any
them.
of both of you, that's for you to deal with. Agreed with what passed it. MVC number.
Again, insurance company again filing execution petition.
1386 of 2022. Dated. Date 22nd January 2024. The claimant is before this court, seeking enhancement of the compensation. The
You
tribunal has
divide
granted
multiply,
it.
na.
This synopsis, it is there. He has not calculated. After calculation, it comes to
Attack
6
multiple
lakhs.
bidutta.
I will put it here. 6,86,374. Then counsel appearing for the claimant submits that. And the evidence of the doctor that he has sustained 50.75% disability to the limb and 16 the disability to the limb. Quota taken 10%.
15%.
Quota taken 15%. Court ought to have taken 17%. It is submitted that on all other heads, the compensation that is awarded by the tribunal is not just and reasonable. It is submitted that the tribunal has already applied the principle of pay and recover. Next paragraph. Then counsel appearing for the respondent insurance company submits that the tribunal, then counsel for the insurance company as well as the owner of the vehicle submits that the court has granted a just and reasonable compensation. No enhancement is called for. Next, having heard the counsels on either side, there is the material not record concerning the 3 fracture injuries that are sustained and the head of pain and suffering. This court is granting 60,000 medical expenses. There is nothing to interfere. Coming to the loss of income in the later period, as this accident had taken place in the year 2022, 15,500 into 4, 62,000. The claimant was in hospital for 9 days towards incidental expenses, 9,000. Coming to the loss of future income, when the doctor had deposed that the disability is 50.75 to the limb, to the whole body it would be 16.8, and this code is taking 17. 15,500 into 12 into 18 into 17 by 100 is 5,69,160. Consider the disability of 18%, loss of amenities 30,000. Towards future operation, this code is granting 30,000. In the light of so-and-so legal expenses 10,000. Altogether, the claimant is entitled for 9,59,258. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 6,86,374 to 9,59,258. The insurance company shall pay the amount and record the same. Enhanced amount
Recovery from the owner of the vehicle.
owner.
One
Your
submission,
direct
there-
to insurance company.
There was single fracture.
Huh?
There was only one fracture.
No members.
As
The two fractures.
can be noticed from page number 22 of the judgment.
Yes.
No,
Sir,
it is three fractures. It is
Read,
there.
read.
Shall I read, my lord? Middle of that, the
Insurance
petitioner
company
had
had-
undergone surgery only for the femur fracture and all other injuries she had undergone conservative treatment.
Not
It's
operation.
not about operation. What are the injuries?
Injuries.
Injuries.
The femur fracture.
Yes.
Cell number 12, Raghu R. Renuka HR for respondent.
Writing TCR is
This
there.
TCR, last occasion, lordship called TCR.
Take this.
It's awaited. TCR is awaited.
Lissus matter in the month of January. Yes, 13.
13. Cell number 13, FS Dabali, KV Nayak.
Claimant Miller.
Yes.
Case of injury murder. The claimant was not riding the motorcycle along with pillion rider. Both bus and motorcycle were moving in the same direction.
We'll take up these matters on another day. All these remaining matters, list on, basing on, look at the matters on 19th, 20th, 26th, 27th, remaining matters.
Serial number 19, my lord. We have submitted that one matter may be delinked and it may,
One, yes,
Cell number 19.
well, I pressed 2 weeks time in that matter, my lord.
yes.
Please.
Tell her.
My lord,
Ask him to go.
my lord, one submission, my lord. List 2 serial number 16 is concerned, but the insurance company is not filed any wakalat. My lord, direct to take notice, my lord, any other advocate.
All that we will not say, Mr. Counsel, now it's over. Whenever it comes, it's not possible for the court. In every case, go back. Yes,
Serial number 16, my lord.
we will
Second
not
list.
look into that now. Look at the matters that are coming and accordingly give the rates. For all only on Thursday and Friday. No, Wednesday and Thursday.
ಇದು serial number 19. Send it to the officer. Dealing this. Dealing payment 7967 of 2005 and list along with payment 7976. Date I will give. That only the.
Madam.
ಯಾವುದು ಸರ್ 7976 2 weeks ಅಂದ್ರೆ you do one thing make a list on 27 2 weeks ಇದೆ ಅಲ್ಲ ಇದೆ 2 weeks ಅಂತ ಹೇಳಿದ್ರೆ ಅದೇ ಬರೋದು ಮೇಡಮ್ ಹೇಳಿದ್ರೆ ನನಗೆ 4 ಡೇಟ್ you for all remaining matters either 20 21 or 27 28
ಇದೇ ಕೋರ್ಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದ
26 ಬರಲ್ಲ
ಮೇಡಮ್ ಹೇಳಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ಸೋ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್
Madam, list 2, serial number 24.
this one only 26 you are saying
Madam, list two.
Madam, so will you or now only you will take
Serial number 16.
sir one ನಿಮಿಷ ಸರ್ ಒಂದು ನಿಮಿಷ ನಾನು ಡೇಟು ನೋಡ್ಬೇಕು ಅಲ್ಲಿ ಎಷ್ಟೆಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಅಂತ ನೋಡ್ಬಿಟ್ಟು ಸರ್ 13 ಆಗಿದೆ ಅಲ್ಲ from 14 I have to 13 from 13 only no ಸರ್ ಇವತ್ತೊಂದು ನೀನು ಇದು ನಮ್ಮ ಮೇಡಮ್ದು ಈ ದಿನ ಈ ತರದ್ದು ಒಂದು ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಡಿ ಬೆಳಗ್ಗೆ ಬಂದಾಗ ಇದೊಂದು ತೆಗೀರಿ ಇವತ್ತು ಯಾಕಂದ್ರೆ ಇದು ನೆಕ್ಸ್ಟ್ ನಿನ್ನೆ ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ ಪ್ರತಿದಿನ ನಮ್ಮ ಮೇಡಮ್ ಮಾತ್ರ ಒಂದ್ ತೆಗಿದೆ, ಚಿಲ್ಕೂರ್ ಮೇಡಮ್ ಇದೆ.